make any gestures during the hearing. Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or to the status of this case as a capital offense. All right. As we begin this morning, I wish to I've taken a lot of time to think about the comments made by the parties yesterday, and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me. And I took the time this morning to review what was filed since we adjourned yesterday until we came back on record. One of the motions filed last night was filed by Ms. Erica Kirk's attorney, and I wish to address that. And I realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed by the attorney for victim representative Erica Kirk to this state.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and indeed honors the victim representative's right to be present in at this hearing.
Thank you, Mr. Ballard. To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading. I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution. I think that the rulings that the court has made the last few days do so, and I don't believe that the issues that are presently before the court going forward with the hearing with respect to exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday. But we have witnesses we have to get to, including a defense witness who is not available after tonight. So I could, of course, as Your Honor knows, say much more, but the court has all the briefing, and I think we should move forward.
Thank you. And as it relates to transparency and publication, does the news media wish to be heard on this issue?
Only briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this three-step process, and I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are three separate inquiries. Of course, the media believes, the media will be the party who stands here at this lectern and says, we believe we should see as much as possible. We're maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on the live stream cannot, is a meaningful victory for transparency, and we, of course, support that.
Thank you. All right.
Your Honor, the state would like to be heard on the briefing, briefly,
For,
the briefing that was submitted last night.
all right, so I want to address the motion filed by the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it all addressed. So in regards to that, and I appreciate the position of the parties, it is important for me to hear all sides. Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness, respect, and dignity, and the right to be present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims' representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery, and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed only to the gallery. And third, if it will be published through the camera to the public at large. This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter, as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to go.
We do want to be heard on the briefing from last night, and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit to that. Is that correct? I
do, and there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record,
Okay.
and then I'll hear from you. I just want to make sure you're able to be afforded everything. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties?
Yes.
All right, the state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
Go ahead, Judge. I think, Your Honor, and then let's just see what the court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed, ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue. I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does. Plus, the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is where I'm going to next. Mr. Ballard?
Yes, Your Honor. I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here, and this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video-only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page, based on what the court just said.
Your Honor, I think we have just a 1 second difference. Our timestamp is 25:22 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it is a good day when we are literally on the same page. I'm glad that within 1 second we are all in agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it, you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well. And this is very short, and so I'll leave it to the state if you wish to just in real time pause and fast forward or wish to redact it. I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes 18 seconds to 27 minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Your Honor, just to make sure that we've got that correct, The additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Yes.
And Your Honor, while we're talking about additional redactions, let me approach. When Your Honor made his ruling yesterday afternoon, it wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence, and I would like to be able to point the court to those. We've got two brief portions that we believe don't implicate those concerns and should not be redacted.
All right.
Does Your Honor have the transcript?
I do.
In front of you? Okay. First of all, at the very, very bottom of page 10, beginning with the words, "was he," and then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see "was he" at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see. Right here. Okay, now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from "was he" on page 10 until
16, the timestamp 1646 on page 11.
okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19. And it begins, let's see. It would be the fifth paragraph down, Mr. McBride stating "okay," and then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
Thank you.
Have you heard?
Yes, you may.
Thank you, Your Honor. With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that was not a section that we asked the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted, redacted transcript,
See that?
and the court agreed with us. This is not relevant. This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twiggs, and now I'm going to quote the Utah Rule of Evidence, has any tendency and reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon, but from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript which we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue prejudice.
All right.
I am not Mr. Twiggs' representative, but I think as a witness who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be, but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything of significance, especially in compared to the undue prejudice. Thank you, Your Honor.
Thank you, Mr. Novak. Mr. Ballard.
Thank you, Your Honors. Mr. Novak recognized Mr. Twiggs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview, and this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him, and then also it's very relevant to the enhancement that we have charged.
All right. Thank you. Anything further before the court rules on these two requests? All right. In reviewing the first section, again, citing to page 10, and I know it is, to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 1539 on the video, starting with was he, and ending at 1646 with the last word asking. After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327. going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct, yeah. Yes. Right after 3255,
All
where
right.
Mr. McBride states, okay.
I see, thank you. Let me just take a quick second to review this. In relation to that request from right after 3255, starting with okay, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with okay, ending at 3327 is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast. I note the, and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds independently that this this portion shall not be transmitted into the courtroom because of certain statements made in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at okay, until just before 3340, I'm sorry, up to 3340 may be published. Did that notation make sense?
Did to the state, Your Honor.
All right, to defense.
Understood.
And so this is the appropriate balancing of being transparent while at the same time maintaining the constitutional rights or balancing the constitutional rights of all parties and what is appropriate for publication. And this may be published not only to the gallery, but to the media as well that goes beyond the gallery itself. All right. Anything further on State's Exhibit 16?
Not from the state, Your Honor. Thank you.
All right. And I note the defense is nodding their head as well and not indicating any more is needed to be discussed at this point. All right. I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Thank you, Your Honor. We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case, and what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence, and Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the statements, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then they immediately, it was the police that immediately released that recording to the press, who then publicized and televised that. The defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate. Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value, and even if it did, the circumstances are completely different than from the types of statements that we're dealing with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And the court, because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No, not
Thank you.
not this time. Mr. Novak.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. It wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom, we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kirk's counsel. The state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that the blanket rule that there is unrebuttable prejudice that's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, a Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them makes them unable to serve. But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case that the Supreme Court talked about in Skilling. We wouldn't have any state action giving rise to this problem if we didn't have cameras in the courtroom. And that's why we think that Exhibits 16.1, 16.2, and 16.3 need to be managed in the way we've asserted. Thank you, Your Honor.
Thank you. Mr. Ballard.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits, unredacted, be published in the courtroom. Not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public, and the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is going to rely on. And that is even more important to the victim representative's right to be able to be present and to observe these proceedings. Thank you.
All right, counsel.
Your Honor, if I may, I'll be brief. I want to begin by saying thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today and the nimbleness that's required to talk about things like the transcript in open court is a challenge. I recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. I know the public does as well. The only thing that I want to say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously in the wake of Rideau. It's obviously in the wake of Estes. It's here in this state, unanimous Utah Supreme Court, upholding a decision made by Judge McCleave below in a case that has striking parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told me that he was involved in the shooting, gave me details of it, threatened me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's a presumptive right of access for the public. The second question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea of sealing a document that contained allegations or details that were already in the public sphere would only create the impression that information was being kept from the public when it was not. We stress what we did yesterday, that as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognize there's a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that information is already in the public sphere. That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But we again do recognize that middle step is a meaningful one, and if the court were to decide that that information be shared in the courtroom but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Counsel?
Good morning, Your Honor. Jeffrey Nyman on behalf of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing. And they have a right to be here, and they have a right to hear the evidence. They have a right to see and feel what's going on in this courtroom, just like, and they want to understand, Judge, what you are viewing. They want to see the evidence. And we understand you have to balance. But at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom, for them to see it. The Utah Constitution gives them the right to be here, and to be here and not to see the evidence, what's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, counsel. Anything further as it relates to exhibits 16.1, 16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to make sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
All right. And just to be clear, as it relates to the state's request, 16 point, well, so under the three factors, or the three levels, admission to the court, publication to the gallery, and then publication beyond the gallery, what is the request for each of these exhibits?
We are asking, Your Honor, we are asking for admission. We are asking for publication within the courtroom, but not publication electronically on to the electronic coverage in the courtroom or of these proceedings. We do want to make clear that once the exhibit is admitted, that the witness will be reading from portions of the exhibit, but again, we're not asking that that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
Thank you. Just the court just wants to. And just for clarification, 16.1 is the text messages, 16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
All right. And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing, how much of 16.1 has been published to the public prior to these proceedings? And this is open to all if you wish to weigh in. I just want to make sure that that's clear because that wasn't really addressed in the briefing, and it's a factor. So I want to make sure that that issue has been presented by the parties if you choose to.
Your Honor, with respect to Exhibit 16.1, some of those text messages do appear on pages 8 and 9. Pages 8 and 9 of the information that is public.
Could you give me a rough estimate or percentage of how much of the total amount of 16.1 appears not in the information? Again, I'm just trying to create a record of what is out there from your perspective, so the court can consider that in its analysis.
Your Honor, State's Exhibit 16.1 is 18 pages total of photographs of text messages. It's approximately 5.5 pages of those 18 pages that are reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly. Anything further from any party? To defense?
No, thank you.
To the prosecution?
No, Your Honor, thank you.
Media?
I'll just point out for the court that in addition to the text messages, I believe, I haven't seen the other exhibits, but I believe that at least the note itself which is another one of the exhibits, is also described in the information.
Thank you. Ms. Kirk's victim representative attorney.
This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened to Charlie. So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered for, again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication within the courtroom and beyond the courtroom. And so this is the ruling as it relates to the briefing, and I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on the state's request to publish Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment. The defendant relies on Rizzo versus Louisiana, Estes, and Skilling, and asks the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rizzo and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rizzo because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing, the defendant's due process interests, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rizzo, Estes, and Skilling. Unlike the broadcast interrogation in Rizzo, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial. This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert, if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish Exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on Exhibit 16.1, because it contains information including a phone number and address to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court. Counsel, how would we like to proceed?
Your Honor, just to clarify the record, the state has redacted that portion. We anticipated that needed to be redacted in 16.1, so we have redacted that portion. We believe that the best way to proceed now is we have the edited video ready that comports with the additional edits that the court has ordered. We propose that we take a break so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming back and playing Exhibit 16.
All right. Okay. All right. I appreciate the caution being exercised by all parties. We'll take a 15-minute break, come back at 10:50. Court is in a brief recess. We'll wait a moment for the public to be able to come back into the courtroom. Back in session. Welcome back. Turning to the state.
I apologize, Judge. We were having computer technology issues. We believe those have been sorted out, but we have not yet had the opportunity to show the final edited versions to the defense.
All right. Well, how much time do you need?
Just as long as it takes to show the video. So maybe 10 minutes.
All right. Well, we'll go into... Well, I want to make sure sufficient time is done to do that. I'm sorry, I didn't realize that we were at this point. We'll be in recess for 10 more minutes. So by 11:05 approximately.
That should work, and also we can inform the bailiff as soon as we're done if it's ahead of that time.
All right. Ready to proceed. I want to be respectful of all time, everyone's time, but all at the same time keep this hearing moving forward. So court is in a brief recess. Court is back in session, noting the presence of the parties, all being present. And where we left off is we were the state was looking to confer with defense to ensure that state's exhibits 16, 16.1, 16.2, and 16.3 were shared. Ms. Hunt.
We have reviewed Exhibit 16 with defense, and it comports with the court's order. At this point, we would like to put Agent Davis back on the stand and continue with displaying that, publishing that.
All right, Agent Davis, if you'd like to come forward. I remind you, you're still under oath. If you'd like to have a seat. There should be a water bottle to your left, and after you're situated, if you wouldn't mind adjusting that microphone and bringing it close to you so the record can pick up your testimony. Ms. Hunt, your witness.
And just for the record and the court's benefit, we have made the edits that the court has ordered. We have shown them to defense. Pursuant to the timestamps that the court ordered, we wanted those to be reflected very clearly. So there are sometimes large gaps of just black, empty, silent space. When there are large gaps, we will fast forward. Some of those are short enough that we'll just let it play, if the court is okay with that, with proceeding that way.
Thank you. I appreciate giving a heads up so all parties know what's going on. Thank you, Ms. Hunt.
So at this time, we would move to publish on the monitors State's Exhibit 16.
All right, and to the media, there is a monitor for your benefit right there next to you. For the camera, there is one for that direction as well as for the gallery.
This meeting is to use your statement here instead of your testimony at a preliminary hearing. Understand that? Mm-hmm. Okay, so in order to do that, I need to place you under oath and also give you an admonition about false statements, okay? First, you do solemnly swear or affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I also need to notify you that you are notified that statements you are about to make may be presented to a magistrate or a judge in lieu of your sworn testimony at a preliminary examination. Any false statement you make and that you do not believe to be true may subject you to criminal punishment as a Class A misdemeanor. You understand that?
Yes.
It potentially could be used as for punishment as a higher offense as obstruction of justice. In addition, I just want to make sure that our recording here is clear that you've also been given a federal agreement and a state agreement granting you immunity from prosecution for materials that you discuss now. Do you understand that? Mm-hmm. Okay. First, we're going to cover some of the things that you've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do. Yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Okay.
And will you describe your relationship with Tyler when you first met him anyway?
When I first met him, I didn't know him super well. He was just a new roommate, so I knew he knew my friend group, and I knew he liked playing games, but that's about it when we first, when he first moved in.
Okay. Before we go on, I realized my mic was muted at the outset. Was yours on, your microphone?
No.
Okay. I'm going to repeat those admonitions just to make sure we got recorded. Okay, so again, I placed you under oath. Just to make a record, I'm going to do it again. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And again, I'm going to give you the false statement admonition.
Sorry, hold on. If they're saying that it's echoing, so
I think this one's mic is on.
Okay, sorry.
Okay, you know, I'll mute my mic.
That's fine.
Okay.
Okay, so we should be good. All right. Is that mic off?
Yes.
Okay, great.
Sorry.
All right, okay, sorry about that interruption. All right, so you said when you first met you were roommates?
Yeah.
Okay. And then at some point, your relationship progressed to something more than just roommates, is that right?
Mm-hmm.
When was that?
I think we started dating 2 or 3 months after he moved in.
Okay. And where did you live at that time?
St. George, in an apartment complex.
And is that apartment the same place you lived when on September 10th?
Yes.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
No, separate rooms.
And at that time, let's say September of 2025, what were you doing with your life? Were you working, school?
I was working. I was doing like bathtub and shower repair and stuff in new construction.
Okay. How about Tyler?
I think he was both working. I think he was working for an electrician company then, and he was also in a trade school for being I don't know, higher like ranking electrician. I'm not sure how the trade system works for that.
Okay.
But yeah, I think he was both.
What was his typical work day like?
I think he'd leave around 7 generally and get back around 3 to 4, depending on like where the job was and how long it was for the day. And then on certain days of the week during school, like semesters, he would then later in the day, I think around 5 or 6, go to school.
Okay.
So, yeah.
Okay. Let's jump to September 10th. Did he spend the night in the apartment the night of September 9th into September 10th?
Into September 10th. Yeah, he did. Yes.
Do you know when he left the apartment on September 10th?
I don't know an exact time. I just know he left early. I heard him leaving, and he just said he had a long drive to work that day, so he was leaving early.
Okay, so early. Any guess as to what when that was?
I don't know. I would have thought it was 5 a.m. because that's when like an early work day was for him, but it was probably more like 4.
Okay.
I'm gonna have him spit out his gum just to make sure that
I can do that.
You're tissue right in front of your laptop.
Oh, here you go.
Thank you. Thank you.
All right, so what time did you get up on September 10th?
Probably like 12 to 1 p.m.
You didn't have to work that day?
No.
And did you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that like automated message.
Okay, 11 p.m.
Yeah.
What about, he asks you here, remember how I was engraving bullets? Was he engraving bullets before this?
Yeah, I don't remember exactly when, but he had said he was planning to go hunting with his family. And he asked me for if we had a Dremel because he said he wanted to engrave messages on bullets. And I just told him where our Dremel was, and told him to make sure he doesn't like set off a bullet on accident in the house. But I didn't really think about it until then.
How long before September 10th was this that he asked about the Dremel?
I don't remember, because he'd been talking about the hunting/camping trip for a couple months, but I don't remember when he was specifically asking to engrave the bullets. So
are we talking like a year before?
Oh no, not that long. It would have been, I'd say at most a month before this was when he was asking.
Okay. Okay. Right. You talked about the note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is Bates number 58. Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay, so where did you find this?
On his desk underneath his computer keyboard.
And I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
All right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
I now want to go to what's been titled 16.2. And do you recognize this series of messages here?
Yeah, that was the server of like his friend that I was mentioning.
Okay, and this is your phone again?
Yeah.
And I'm assuming you recognize it because the big crack up at the top.
Mm-hmm.
And so this is a server. Is this Discord?
Yeah, this is Discord.
And who are members of this server? I don't want names, just generally. Who are these people? Who are members of
this is his friend group. They played D&D together every week.
Okay. And I just want to scroll through this to make sure that you get a chance to take a look at it. Or go to the next page.
Mm-hmm. Or yes.
So Tyler Icom, who's that?
That's Tyler Robinson.
And these other people are just others that are members of the server.
Yes.
Jug, Barnaby, Marina, DM.
Mm-hmm.
Yes.
Yeah, like DM means Dungeon Master. So this is these are like most of them are names they're using in the game they're playing currently.
Got it. Yeah, it looks like the last text from Tyler looks like it's 8 p.m. And do you know what day this would have been? 8 p.m. on the 10th or the 11th?
I would think that would be the 11th. Because at least I think so, because I don't think on the 10th that he messaged anyone before me at like 11. So.
And he turned himself in on the 11th, right?
I thought so, yeah.
So again, we're just going to go through this so that we have a record of the messages. Is that an accurate recording of that thread?
To my knowledge, yes.
And that was sent, looks like between September 10th and September 12th. Looks like the last day on this is September 12th. Screen?
Yes.
Okay. All right, so again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time did you see Tyler on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting?
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I think I saw him after that message where I said I'll come home and say I'm doing laundry, because I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home, and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home?
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. He started crying a little bit and said he wishes he hadn't done it, and then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
Okay. Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat,
Okay.
but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images. Okay, I'm on the FBI's website. You can see the URL there at the top. This is some press release about this event. And here on the screen, you see these, looks like there's 2 rows of 3 images.
Mm-hmm.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So it definitely, especially the bottom, the last 2, definitely do look like him. Oh, they do look like Tyler Robinson.
And you talked about that with your friends, right? This looks like him.
Yeah, his friends. Yeah, I don't know if I talked. I don't remember if I talked about it with any of my friends. And then since I didn't have my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
Okay. All right, I want to back up a little bit now. We've talked about September 10th, but let me get a little bit of context here. So, did you game with Tyler?
Yeah.
What kind of games?
We played some just kind of party games together, like anything that would be multiplayer with a group of friends. There was one game he really liked called Sea of Thieves, where you play as like a pirate, and you can fight against people, but most of it's just like fishing, fighting sharks, skeletons kind of stuff. We played some co-op games where it's like you both have to work together to win in whatever way. Way back when I was just out of high school, when I first knew him online, we played some like shooting games together, but I didn't know him very well, so that was just when we had like a whole friend group on to play, and he was someone that my friends invited.
Okay. Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in like their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did you ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay. How about political issues? So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current like policies being like issued or voted on, I think. But yeah.
Okay, so before that you have been?
For a short time, yes.
Okay. And I understand you're going by Luna at some point?
To some people, yeah, but not as an overall thing.
Okay. Okay. I think that's all the questions I have for this portion. Let me check and see if I've missed anything. The Dremel that you talked about, you said he had asked for that, is that right?
Mm-hmm.
And had he told you it was to inscribe bullets?
Yeah.
And so did you have a Dremel then?
Yeah.
Okay.
It was in our our apartment, we had a section where we kept all our like random tools for household stuff in our lower basement level pantry. So yeah.
Okay. And did you give that to him or tell him where it was?
I just told him where it was, yeah.
Okay, I'm going to go ahead and end the recording for the 1102 purposes.
All right, that concludes State's Exhibit 16. Ms. Hunt.
Thank you, Judge. Agent Davis, I asked you yesterday, but I want to remind the court and those present. Were you physically present at the interview we just watched in State's Exhibit 16?
Yes, I was there.
And aside from the court-ordered redactions, did it appear to you to be fair and accurate about what you remember that interview that day?
Yes, yes, I do.
During that interview, did Mr. Twiggs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, a Discord chat messages, and a handwritten note.
And then we also saw in the video, he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
Have you reviewed all of those items as part of the investigation?
Yes, I have.
You're familiar with them?
Yes.
All right, I want to put just on the witness's screen what's been marked for identification as State's Exhibit 16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
I see it. I see it now.
Do you recognize this?
Yes, I do.
What is it?
This is a photograph of screenshots of text messages between Tyler Robinson and Lance Twiggs. This is a photograph of Lance's phone.
So sorry, you said photograph, you also said screenshot. Can you differentiate or clarify there?
Sorry. These are photographs directly from Lance's phone.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time, his phone was photographed.
And you testified, I believe yesterday, that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at a picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
And you kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th, he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview he refers to the large crack in the upper left screen. So he identifies that in his second interview that was given on April 20th.
And according to your review of the recording of his first interview and in speaking with the agents that were there, did he have his personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview sorry, let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twiggs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
Is State's Exhibit 16.1 a fair and accurate representation of the text thread between, or the relevant text thread between Mr. Twiggs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twiggs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twiggs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
All right, Judge, I would move to admit State's Exhibit 16.1, and then pursuant to court order, I would move to publish it to the monitors.
Mr. Novak.
We have no further objections beyond those that the court, of course, is very familiar with at this point in time.
All right, I'll note the standing objections made by defense. Those objections are overruled. This 16.1 is admitted into evidence and may be published to the gallery as well as electronically distributed through the camera.
All right, Agent, I'm not going to go through every single message, but I do want to have you read aloud certain portions of them. And I apologize to counsel, these are not actually given a page number. I have page numbers, but I'm happy to confer that we're on the same page as we go. So here we're looking at page 1 of State's Exhibit 16.1. If you could read a little more than halfway down where it begins Wednesday, 11 p.m., will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize, let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
If we could scroll down to page 2. And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
We could scroll down to page 3. Continue reading.
Lance says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, or sorry, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading about halfway down. I'll stop you about halfway down.
It says, while they were spot, but I don't want to chance it while they were parked there. If they had found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there. Let's move to page 5. So this should be page 4, so just scroll down 1, please, Kimberly. And if you could read starting, sorry, Kimberly, scroll a bit more down. If you could read, I don't know, about a 1/3 of the way up that starts with guess.
Okay. Tyler says, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off.
And continue.
And Lance says, are you okay still? And Tyler says, yes, check and spot again now. Will.
Sorry, now we're on page 6. Continue reading.
We'll update soon. He continues, the squad car was moved further away enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so fucking loud. Gonna see if the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be in the wrong spot. Lance says, do you think they found it? And Tyler says, dunno, they haven't published anything if they have. And then Lance says, why did you leave it behind?
Oh, sorry, Kimberly, if you could scroll down.
Originally. Also, does it have a serial number?
We could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if it had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with.
And stop there, please. And then if we could go to the next page, page 8. And if you could start at the top.
Okay, so Lance says, was your change of clothes there or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun or would he notice? Then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it was old as shit and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm going to have to leave it. That really fucking sucks.
And let me stop you there. And then if we could go on to the next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes. So Lance says, do you need it for hunting? And Tyler says, no, my dad wanted to use a high caliber for the rifle hunt. Judging from today, I say Gramps' gun does just fine. IDK. I think that was a 2K scope. Lance says, geez. And then Tyler says, OMW home 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15. And then the second grade message on page 15, if you could start there.
Okay. So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Okay.
And we can remove the exhibit from the screen. Thank you, Kimberly. We mentioned a Cellbrite extraction in Mr. Twiggs' phone. Do you know what time that last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
I'm sorry, September 11th?
Yes.
Would September 12th make sense, or you're saying September 11th?
So September 11th was when he turned himself in.
Okay.
Would have been September 11th, yeah.
Okay, thank you.
Yeah.
All right, I'm going to show just for the witness, States Exhibit 16.2. Let me know when you see that.
Okay, I see it.
Do you recognize this?
I do, yep.
What is it?
This is just more photos of Lance's phone. And
How
these
do you-
are, these are sorry, I had to blank. Sorry, go with your question, please.
I'm just asking what it is. So you said it's a photo of Lance's phone. Do you know if that's from the same time period as the exhibit we just looked at?
Yes.
And what is it of?
These are the Discord messages of that Lance had talked about.
How do you know that?
So Lance, in the first interview with FBI, shows the phone. The photos are taken by Agent Larson, and then these images are shown to Lance during a second interview, and he confirms that these are those same messages, and this is photos of Lance's phone.
You mentioned an Agent Larson took the photos. Do you know if he's the same agent that took the photos of this exhibit, 16.2?
Yes, same agent.
And you spoke with him to confirm that?
Yes, I did.
Are you aware if Mr. Twiggs is actually part of this Discord thread?
Yes, he is a part of it. He doesn't, in this section, he doesn't reply to it, but he does state in his statement that he was part of that thread.
Does he identify whether Mr. Robinson is part of that thread?
He does.
And when did that happen?
He identifies that in his first interview with the two FBI agents, and then he again confirms that in his second interview.
Did Mr. Twiggs say what username on Discord Mr. Robinson used, at least with respect to this thread?
Yes, it's the Tyler/Icum, IKUM.
And is Exhibit 16.2 a fair and accurate representation of that Discord thread?
Yes, it is.
Did law enforcement send, as part of your investigation, did law enforcement send a subpoena to Discord?
Yes, they did.
Were these messages recovered via that subpoena?
They were.
Did you review that?
Yes, I did.
And in States Exhibit 16.2 that is before you, when is the first message from Tyler sent?
7:57 p.m.
And it says yesterday. Do you have any knowledge of what day that would have been?
Yes, this would have been September 11th.
So Tyler sends the first message that you're seeing on Exhibit 16.2, September 11th at 7:57 p.m.
Yes, that's correct.
You testified earlier that Mr. Robinson arrived at the Washington County Sheriff's Office approximately at 9 p.m., is that right?
Yes, that's correct.
And although you weren't physically present there yet because you were flying down, how do you know that he arrived approximately around 9 p.m.?
Just based on the police reports I reviewed and then go back and look at the video and such.
Judge, the state moves to admit State's Exhibit 16.2 and publish it pursuant to court order.
Mr. Novak.
Thank you, Aaron. We've already lodged all of our objections on all 3 phases.
All right. Noting the objections, standing objections by defense. State's Exhibit 16.2 is admitted into evidence and may be published only in the gallery, not for distribution on electronic media.
I see it.
Do you recognize this?
I do.
What is this?
This is a handwritten note or letter from Tyler to Lance.
How do you know that?
In Lance's first interview with FBI, he tells them about this letter note he found under Tyler's keyboard per a text message he received. He states from 11 p.m. on September 10th. And so at that point, Lance finds this. This is the letter he finds under that keyboard.
Okay, so to clarify, Mr. Twiggs gets a text from Mr. Robinson around 11 p.m. on September 10th, telling him to look under his keyboard.
Yes, correct.
And this is what Mr. Twiggs represented was underneath the keyboard.
Yes, yes.
How did law enforcement get this photograph?
So following Lance's first interview at St. George PD, his phone is recovered at that point, taken into evidence. It is downloaded, I believe it was the following day or shortly after that. The FBI transported that phone to the RCFL, which is the Regional Computer Forensic Laboratory in Salt Lake City. The phone was downloaded through Celebrite, and after that, following that download was complete, SBI received a flash drive containing that download. From there, it went to a SIAC analyst to go through that data of his phone to look for any pertinent evidence or information that may be on there. And at that point, that this image of this letter was located.
All right, I'm going to break down a few things. You mentioned, I just want to make sure the record's clear. You mentioned Celebrate a few times. What is Celebrate?
It's a downloading software that's commonly used by law enforcement. I don't do that myself, but it's commonly used to recover data, to download electronic devices, particularly cell phones.
And then you mentioned SIAC. What does that mean?
It's the Statewide Information Analysis Center. It's a division within DPS. It's a fusion center. They assist law enforcement with intelligence, various intelligence information for our investigations.
You mentioned that you don't personally do Celebrate phone extractions. Have you spoken to the law enforcement officers that performed the Celebrate extraction on Mr. Twiggs' phone in this case?
I don't believe I specifically talked to those individuals, the RCFL, that did that. But they, yeah, that was then provided to SBI.
Did you speak with officers at SBI that have recovered this photo that we're seeing in State's Exhibit 16.3?
Yes, I've spoken to, I have spoken with an SIAC analyst who in particular found this image. I've spoken to her personally as well.
Was Mr. Twiggs shown what's been marked as State's Exhibit 16.3 during his second interview?
Yes, he was.
And again, you were present for that?
Yes, I was there.
Is Exhibit 16.3 a fair and accurate representation of the photo law enforcement obtained from Mr. Twiggs' phone and that he was subsequently shown in the second interview?
Yes, it's fair and accurate.
Your Honor, the state would move to admit Exhibit 16.3 and then also publish pursuant to court order.
Mr. Novak.
Just noting the objections that have previously been made, and I think that the court's order is that it may be published in the courtroom only.
Thank you. Noting the standing objection by defense, 16.3, correct?
Correct.
Is admitted into evidence and may be published only in the courtroom and not be shown or videoed.
I do.
What is it?
These are the images that the FBI released to the public. That would have been on September 11th when those were released. And this was, those were those images that went public of the suspected EVU shooting suspect.
How do you know that?
I've viewed the FBI's website, and I recall seeing these images released on September 11th.
Does State's Exhibit 16.4, is that a fair and accurate representation of what you reviewed from the FBI and that the FBI released?
Yes, it is.
The state moves to admit Exhibit 16.4 and publish according to court order.
Mr. Novak.
No further objections, thank you.
All right, noting the standing objection by defense, overruling that objection, State's Exhibit 16.4 is admitted into evidence and may be published in the courtroom.
And again, in the Discord,
As it relates to 5.1, the court previously, the day that I did it, I believe it's day 2, perhaps,
That sounds correct.
the court provisionally admitted it, contingent on additional foundation being laid, whether through testimony or through evidence. And the court notes that such foundation and testimony has been laid in order for the foundation to be laid for 5.1 to be admitted into evidence for full consideration by this court. And so that is received. As it relates to publication and taking in consideration the argument by Mr. Novak, well, first noting the objection, the standing objections by defense, that is overruled as it relates to the admission to 5.1. But going to the publication, the court understands the argument made by defense that this is going toward perhaps religion, and that the enhancement, and let me just read that from the information, victim targeting enhancement in violation of Utah Code annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression, and that was also noted as an enhancement for count 2 and count 7. The court is not going to engage, the court can weigh how this is applied, but it finds it relevant, how it relates to the enhancement is for the court to weigh as it looks at the bind-over decision, and is not engaging in that decision-making today, but finds that it is relevant, it is admissible to the court, and is publishable to the gallery as well as to the public. And so if the state wishes to publish State's Exhibit 5.1, it may do so at this time.
Thank you. Yes, we do. And Kimberly, I don't know if we want to use the same kind of slow scrolling. Thank you. All right, I believe that should be sufficient. And Agent Davis, I apologize. I'm going to take you very briefly back to State's Exhibit 16.1, which is the text thread between Mr. Robinson and Mr. Twiggs. Kimberly, if you could turn to page 17. And because this has already been admitted and, court, correct me if I'm wrong, published not only to the gallery but to cameras at large, I'd ask that it be displayed in that fashion again.
All right. Any input from any other party on that request? No. All right, thank you. Thank you. It may be published, and the media may pick this up as well.
Agent Davis, if I can direct you to the very last message on that page, starting with "if any," if you could read that out loud.
Okay. This is Tyler. He says, if any police ask you questions, sorry, let me start over. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure the police follow.
Okay, thank you. That's all I need from that exhibit. And then finally, Agent Davis, you testified before that you flew down to Washington County Sheriff's Office and observed Tyler Robinson there, correct?
Correct. Yeah.
You got his name there?
Yes.
You stated that you transported or assisted transporting him up to Utah County Jail?
Yes.
And that you were the booking officer?
That's correct.
Do you recognize Tyler Robinson here in the courtroom today?
Yes, I do.
If you could point him out and briefly describe something that he's wearing.
He's the individual seated at the defendant's table in the center chair with a gray suit coat and a green tie.
Your Honor, if record could reflect identification of the defendant.
Counsel?
No objection.
All right. I'll note for the purposes of this hearing only that Agent Davis has identified Mr. Robinson in court. Thank you.
And Judge, if I can just have a moment.
You may.
Ready to pass the witness, thank you. And I don't know if now would be a good time for lunch.
All right. We'll go ahead and break right now for lunch for 1 hour, well, 1 hour and 5 minutes. Let's come back at 1:30. We'll resume. We'll pick up the defense for cross-examination if they choose for Agent Davis. Does either party need the benefit of the record before we go on our lunch break?
Not the state.
No cross-examination for Agent Davis, so I don't want him to wait here if he has other things to do.
Thank you.
Thank you, Mr. Novak.
Thank you.
No cross-examination. May this witness be excused.
Yes.
All right, Agent Davis, you may
Thank you.
step down,
Thank you.
and then we'll resume with the state on their next witness. Court is now in recess.
All right.
Please be seated. Court is back in session, noting the presence of counsel and all parties. We left off with Agent Davis being excused from the stand, no cross-examination, and turning to the state. Are you ready to proceed?
State Call Sergeant Jennifer Falmolina.
All right, Sergeant, if you wouldn't mind coming forward and being brought into the courtroom. Right, Sergeant, if you'd like to come forward, you're still under oath from your previous testimony from the previous day. So if you'd just like to come up to the witness stand, be seated to your left. Behind the monitor should be a bottle of water. After you're situated, if you wouldn't mind just pulling that microphone toward you to ensure that the audio is picked up. Mr. McBride, your witness.
Sergeant Falmolina, good afternoon.
Good afternoon.
We briefly covered some of your involvement in this case the other day. I want to return back to your initial assignment to this case. When were you first assigned to go to the campus of Utah Valley University?
On September 10th of 2025.
What time did you get that assignment?
I believe it was approximately 1:30 p.m.
And where were you when you received that assignment?
I was at a headquarters office in Salt Lake.
And did you go directly down to the campus?
Yes, I did.
And will you describe what you're seeing as you arrived there?
Yes, when I arrived there, I actually arrived onto or near the south end of campus, and that's where I saw multiple police cars as well as multiple officers from various agencies. Then I was asked to respond to our command post, which was in the Fugel building there.
And the Fugel building, we've had some testimony about this, but is that just to the south of the courtyard?
Yes, that is.
And were you there while officers were securing campus?
Yes, I was.
And do you know generally how that was done?
I don't know the specifics, but I do know that officers were canvassing the area, trying to look for a suspect, but also trying to see if anyone else was injured, and then making sure that the scene was secure and that no unauthorized people were allowed in.
And I think you testified earlier. What was your primary assignment?
My primary assignment at the campus, as well as throughout the case, was to oversee the crime scenes as well as the physical evidence.
Before you could do your work on the crime scenes, did the campus have to become secure?
Yes, it did.
And did that involve making sure there was no active shooter on campus?
Yes.
And did that involve officers searching buildings and clearing buildings throughout campus?
Yes.
You mentioned that were there multiple areas that were processed by you and other crime scene analysts in this case?
Yes, there was. Would you like me to go over them?
Let me direct you to a few of them. Well, yes, please mention the scenes.
Yes, so one scene was a courtyard area, or I guess what we could also refer to as the amphitheater where the event took place. The other scene would have been the Fulton Library, where there were two bus stops. And then another would have been the wooded area, and then the last one would have been the Lolosi Center building, as well as the ground below.
All right, let's start with the rooftop. What was who was assigned to process the rooftop area?
The team that was assigned to process that was the Utah Bureau of Forensic Services, or also known as our state crime lab.
And generally, what does processing an area involve?
Processing includes documentation, sketching, as well as taking photographs, marking, as well as labeling evidence, and then determining how to package them properly, as well as also just trying to ID anything probative.
On the rooftop was evidence found.
Yes.
What types of evidence were found on the rooftop?
One item of evidence that was found was a screwdriver. Another one would have been what we believe was the shooter's perch. That was determined that was easy to see at night. Using oblique lighting, we could see disturbances in the gravel on the rooftop. And then on the northeast edge, our team also found some swipes on the ledge of that rooftop that was also collected.
Okay, so northeast ledge, and is this the dropping off point?
Yes, it is.
You said swipes. What does that mean, swipes?
Swipes is, I would describe it as kind of hand marks or any type of marks that is left by something that causes some type of disturbance.
Okay, and where on the ledge were those located?
Those were located right on the edge of that right on the edge of that rooftop. And then right below, we also had some other swipes as well as some other impressions. And then below that was a glass window where we also located some latent prints.
Okay, I want to return to what you've referred to as the perch, the sniper position. Were measurements taken from that sniper position to the tent where Charlie Kirk was seated?
Yes.
Do you know the distance?
Yeah, so the distance from the perch area directly to the tent where Mr. Kirk was sitting was approximately 415 feet. If you break it down, so from the perch to the tent, you're looking at it basically like this. And this is the perch and this is the tent.
And now you're describing, I'm sorry, I have to make a record. You're describing an angle, a slope downward from the perch to the location of the tent. Is that accurate?
Yes, I am.
Okay,
Thank
go
you.
ahead.
Yeah, so the angle, so again, the distance, the perch to the tent was approximately 415 feet. If you think about it, or without taking into account the elevation drop, it was actually 410 feet, so just horizontal straight across. And then the elevation difference between that is approximately 68 feet.
Okay, 410 feet from the perch to the tent with a 68-foot vertical drop. Is that
Yes.
right? On the rooftop, were shoe impressions found on the rooftop?
Yes, there was.
Did those who processed that area of the crime scene collect the latent prints and the shoe impressions that you've talked about?
Yes, they did.
And this is a good point to read a stipulation into the record.
All right.
The language of this has been agreed upon by the parties. The parties stipulate that investigators at the crime scene observed latent fingerprints and a palm print on a glass window near the area where the individual landed when the individual jumped from the rooftop of the Low-C Center at UVU. SBI fingerprint examiner Elisa Farmer examined images of these latent fingerprints and the palm print and determined that only 3 of the latent prints, 11B, 11C, and 11D, were of comparable or of poor comparable value. She excluded Tyler Robinson as the source of any of these 3 latent prints. Ms. Farmer reviewed other prints on the window and found that they did not have adequate value for comparison. Subsequent examinations of these 3 latent or actual latent prints by the FBI were inconclusive. That area that was described in that stipulation, is that the area in the glass window that you're talking about?
Yes, that is.
That's on the northeast corner of the Low-C Center?
Yes.
And that's the area where we see in a video an individual drop from the roof?
Yes.
I want to move on to another area, the courtyard. First, will you describe what that area of the crime scene looked like?
Yeah, so when I arrived on scene, you have different steps. I believe there were maybe like 5 or 6 covered in grass. When I was there, there were personal belongings spread throughout. There was a tent towards the west end of that courtyard area, as well as some banners and some barriers as well.
Was that area processed for evidence as well?
Yes, it was.
What was done to process that area?
Photography, as well as just examining the tent area to see if there's anything there.
And who is assigned to process the courtyard area?
The FBI.
I want to take you to another area, a wooded area. Was there a wooded area that was processed as well?
Yes, there was.
Will you describe, first off, where that area is?
Yes, so this area is located northeast of the Lolosi's Center building, and it is across from Campus Drive.
Your Honor, could we publish Exhibit 35, please?
Yes.
And if I may approach the witness, I'll put up the hard copy of this exhibit as well.
All right.
Can we publish the oh, thank you. All right, on the screen in front of you, will you take a look at Exhibit 35?
Yes.
Do you recognize that?
Yes, I do.
Will you take a moment to orient yourself on that map and tell me when you've found the relevant points that help you understand what this map is of?
Yes.
Do you see the courtyard on that map?
Yes, I do.
Kimberly, can you zoom in to the courtyard area, kind of the center of the... There's a pointer on the screen. Is that the courtyard?
Yes, that is.
All right, now, the Low-C Center, will you describe... well, let's jump to the wooded area. Where is the wooded area that you're talking about, seeing that was processed?
Yep, the wooded area, if you go from the courtyard and you go northeast, you're going to come across this big parking lot. And then if you just go directly north to that.
Okay, at this point, it might be easiest for you to actually indicate on the physical map. If you don't mind just standing up, give you a handheld mic here.
Yes, so the wooded area is approximately right here in this area.
Okay, so just to make a record of the area, on the northern, I guess I'll say, and north is up on this map, is that right?
Yes.
Do you know where Campus Drive is?
Yes, Campus Drive is this road that winds right along here.
Okay, and so that's kind of the windy road that begins in the upper left-hand corner of the exhibit and winds down through the center of the map and kind of exits to the middle right side of the map, is that right?
Yes.
And the wooded area, where is it in relation to the Campus Drive?
It is north of Campus Drive.
Okay, kind of in that, probably the center right of the map, is that right?
Yes, that's correct.
Will you describe, first off, what is on the south side across the street from the wooded area?
Yeah, so on the south side of the south side of the wooded area, we have the computer science building, which is to, I guess, east. And then we have a parking structure, and we have a walkway along here in between that connects the computer science building and the Lolosi's Center building. And then right onto the southwest of the parking lot area is going to be the Lolosi Center building.
Okay. Now, you referred to the area across the street from the wooded area as a parking structure. That's a parking lot, right?
I'm sorry.
And there is a parking structure on campus, correct?
Yes, there is.
But that's different than the parking lot you just mentioned?
Yes.
Okay. All right. Back to the wooded area. What was found? Was anything found in the wooded area of evidentiary value? You can sit down. Thank you. You can take that.
May you repeat your question?
Was anything of evidentiary value found in the wooded area?
Yes, in the wooded area, a rifle that was wrapped in a dark colored towel was found there.
And how did you learn about that?
I found that out because just a little bit before 6 p.m., That day I received a call from Utah County Sheriff's Office, who was tasked with searching that area.
Do you know why they searched that area in the first place?
Yeah, so they searched that area because I received a video that was from the UVU security footage. This was received by our command post on scene, and it showed who we believe was the shooter on the rooftop run from the southwest corner all the way to the northeast corner, jump down, and then continue to the northeast side of that campus, and then cross the street to Campus Drive, and then the suspect was out of camera's view after that.
Okay, so he ran basically toward and into that wooded area.
Yes.
All right. What were you told from the sheriff's office?
I was told that they found a gun, and from there I asked them to hold the scene, and that myself and FBI ERT team, the lead, Special Agent Kamak, would be en route.
Okay. FBI ERT, FBI Evidence Response Team, right?
Yes.
All right. Did you go to that area?
Yes, I did.
Did you observe the weapon?
Yes.
Will you describe what you saw?
Yep. What I saw was a rifle that was, or at the time before even having removed it, we found, or in the bushes, we found all you could really see was just a dark towel there. So pictures were taken of that, and then eventually the gun or the towel was removed, and then once we removed the towel from the bushes is when we uncovered that the towel was actually used to wrap the gun in.
Have you reviewed State's Exhibits 10, 10.1, 10.2, and 10.3? Do you remember reviewing these?
Yes.
And are they accurate photographs of the weapon when it was recovered and shortly thereafter?
Yes.
I move the admission of State's Exhibits 10, 10.1, 10.2, and 10.3.
Defense?
No additional objections.
All right, and as it relates to publication, if any?
Yes, I would ask that these be published at all three levels.
All right, any input, Mr. Burt?
Same objections.
All right, I'll note the standing objections from defense. Those are overruled. And 10.1, 10.2, 10.3 are admitted into evidence and may be published both in the courtroom and through the use of the camera.
If we can please publish number 10, thank you. You have in front of you on the screen Plaintiff's Exhibit 10. Will you describe what we're looking at here?
Yes, what we are looking at here is actually the bushes where the dark colored towel and the gun were found. You can kind of see the dark colored towel towards the right-hand side of the screen in the middle, right middle.
Kimberly, can you zoom into that area, please? All right, is this a better view of the towel?
Yes, it is.
If we can go to Exhibit 10.1. Will you describe what we're looking at in Exhibit 10.1?
Yes, this is a mid-range shot of, again, the towel that was used, or of the towel and within the bushes.
All right. When this was found and you arrived on scene, what happened with that weapon?
We moved it from the bushes, or say FBI Special Agent Kamak removed it from the bushes. We then placed it on a cardboard box, took pictures of it, and then we removed the towel, packaged the towel separately, took additional pictures of the gun, and then rendered it safe on scene.
Okay, I'll ask you about that more in a minute, but let's go to number 10.2. Will you describe what we see here?
Yeah, so what you see here now is the dark colored towel and the rifle that is in the towel, and it is in a cardboard box.
Why is the towel still around the gun?
We wanted to document as to how it was found.
All right, let's go to 10.3. Is this the rifle?
Yes, it is.
You described making the rifle safe. Will you describe what that is?
Yep, so what that is that we ensure that there isn't anything in the chamber and that there's no other cartridges in the gun that would have it go off. So to do that, because it is a bolt action gun, we would have to manipulate the bolt or the lever back, and then from there see if anything was in the chamber, and then I'll say carefully remove anything that was in the chamber and below it.
All right. What is the difference between a bolt action and an auto ejecting gun?
Yep. A bolt action is one where the user actually has to manipulate the bolt. So they would actually have to turn, or they would actually have to pull it back and forward to, whether it be to load it, lock it, as well as extract anything that's in it. Unlike a semi-auto gun, that is one, every single time you pull the trigger, a bullet will be fired, and then from there, a casing will be extracted out, as well as a new cartridge will then be automatically fed into the chamber.
So if you shoot a bolt action rifle, does that spent shell casing automatically exit the gun?
No, it does not. It will stay in there until the person that is handling the gun actually removes the bolt, or actually pulls the bolt back, and then the casing will be extracted out.
Were you present when this weapon was made safe?
Yes, I was.
Will you describe what was found when that happened?
Yep. So when we rendered the gun safe, we found in it, when we removed the bolt back, we found one 30-06 cartridge case, or say a fired cartridge case, and we also found 3 unfired cartridges, all with engravings on them.
Okay. I want to make sure we understand the language you're using. When you say cartridge case and you say cartridge, what do you mean?
Yep. So a cartridge is basically the round itself, right, the whole round. And the round consists of the cartridge case, and then the powder, and then the bullet on top. So the cartridge case, the term is used for something that has been fired already. A cartridge is an unfired round.
Okay. Cartridge is the unfired round that still has the bullet, the powder, and all that.
Yes.
Cartridge case is the fired, is a round that has been fired, and it's just the empty brass casing. Is that right?
Yes.
Okay. Was there any, so there was, I just want to make sure I understand, a fired cartridge case and 3 unfired cartridges?
Yes.
Was there anything distinctive about these items?
All 4 of them had engravings on them.
Did you observe those engravings?
Yes, I did.
Did you observe them right there on scene?
Yes, I did.
And what was done with, let's talk about each of those things. First, the towel. What was done with the towel?
The towel was packaged and then it was eventually provided to the FBI.
What was done with the firearm?
The firearm was also packaged and then provided to the FBI as well.
Was the firearm, did the firearm go to the FBI or the ATF?
Oh, sorry, correction. First it went to the FBI, and then to be in their custody, and then it was then sent to the ATF lab.
Okay. And the rounds, the cartridge and cartridge cases,
Yep.
cartridges and cartridge case.
Yes. All those were packaged, originally provided to the FBI, then was sent to the ATF lab.
Right? And were each of those items tested?
Yes, they were.
And in the testing, were they photographed?
Yes.
Have you reviewed the photo, and were they photographed by the ATF when they were tested?
Yes, they were.
Have you reviewed their photographs?
Yes.
And were you previously shown States Exhibits 19, 20, 21, and 22?
Yes.
And are those photographs that the ATF, or that you received back from the ATF, of those cartridges and the cartridge case?
Yes.
Did they have the same appearance and etchings that you saw when you observed them removed from the gun?
Yes.
And did those photographs accurately capture those etchings?
Yes.
I move to admit States Exhibits 19 through 22.
Mr. Burt.
Additional objections.
All right, I'll note the standing objections. Those objections overruled, and 19, 20, 21, and 22 are admitted. And as to publication, Mr. McBride.
I would move to publish these exhibits at all 3 levels.
All right, any further objection from?
No further objections.
Thank you. Again, I note the standing objections as are overruled. They may be published both in the courtroom and captured by the media camera.
Let us start with Exhibit 19, please. What are we looking at here in Exhibit 19?
This is the cartridge case that was recovered from the gun.
And what position was this in the gun?
This was this is what was in the chamber.
Okay. And the chamber meaning that's where a cartridge is before it's, or when it is fired, correct?
Yes.
Do you notice an inscription or an etching on this cartridge case?
Yes, I do.
Will you read what that says?
Yes. Notices bulge.
And if we can go down to page 2 of the exhibit, will you read what this says?
OWO, what's?
And to page 3?
This.
And question mark, correct?
Yes, question mark.
All right, if we go to State's Exhibit 20. Is this a photograph of one of the cartridges that was found in the gun?
Yes, it is.
And what are we looking at here in this view of page 1 on Exhibit 20?
This is the head stamp of it, and it says it is according to the head stamp, it is a Remington 30-06 Springfield.
Is that a different caliber than a .223 round?
Yes, it is.
Will you look at page 2 of Exhibit 20? Will you read the markings here?
A fascist.
And page 3?
Catch.
And page 4?
Up arrow, right arrow, down arrow, down arrow, down arrow.
All right, let's go to Exhibit 21. And was this another round that was found in the gun?
Yes.
Will you read the inscription here?
O Bella Chow.
Page 2.
Chow Chow.
All right, let's go to Exhibit 22. Another round that was found from the gun, correct?
Yes.
Will you please read the letters here?
If you read.
Page 2.
This, comma, your, or correction, this, comma, you are
Page 3.
gay.
And page 4.
LMAO.
All right, after processing the scenes there at Utah Valley University in Orem, did you go to St. George?
Yes, I did.
And what was your role in St. George?
My role was overseeing the execution of the search warrants at both Mr. Robinson's residence as well as his parents' residence.
And we've had testimony that Mr. Robinson was arrested there. Was he fingerprinted and his DNA taken?
They were actually taken at the Utah County Sheriff's Office jail.
After he was transported to
Yes.
Utah County? Okay, you said that there was, were items of evidence collected from him after he was arrested?
Yes, there was.
From his person. What were those things?
They were his clothing that he was wearing at the time of his arrest, to include shirts, pants, underwear, as well as shoes and anything that were in his pockets.
Do you remember what tops he had on?
I believe it was a maroon top.
And was there any other top layer that was collected that you recall?
I don't recall.
Okay. let's go to, you said there were a couple of homes that were searched there, is that right?
Yes.
Whose homes was that?
One of them was where Mr. Robinson and Mr. Twiggs resided, and the other was Robinson's parents' residence.
I want to ask you about the defendant's home. What items were, will you describe some of the items that were collected from that home?
Yep. Some items collected in that home were a Dremel tool and its bits container, as well as two Remington boxes of 30-06 ammunition, as well as some 30-06 cartridge cases, and a handful of long guns or rifles, a revolver, as well as a burned paper.
All right, I want to ask you about clothing as well. Was any clothing collected from the townhome?
Yes, there was.
How about shoes?
Yes.
What kind of shoes?
2 shoes were collected from the home. One was a Converse shoes, gray in color with white laces, I believe a size 10.5. And then another Converse shoes that were also gray, but had gray laces instead, but were of a different size that I can't remember.
I think you said that you collected boxes of ammunition. Do you remember what caliber that ammunition was?
Yes, there are a handful, but the one that I recall was 30-06.
And you also said you found some cartridge cases. Do you remember what caliber those cartridge cases were?
Yes, those were also 30-06.
If we can display just to the witness Exhibit 23. Do you recognize Plaintiff's Exhibit 23?
Yes, I do.
And is that an accurate photograph of the cartridge casings and some of the bullets that you found?
Yes.
I would move the admission of Plaintiff's Exhibit 23.
Mr. Burt?
No further objections, Your Honor.
All right, I'll note the standing objections by defense. Overrule those objections and admit into evidence State's Exhibit 23 as to publication, Mr. McBride.
I would move to publish at all 3 levels.
All right, it is published to the courtroom as well as maybe broadcast via the camera.
As that's coming up, where did you find these?
I found these in what we would consider the spare bedroom, right next to Tyler's bedroom, on top of a safe.
How do you know which bedroom was Tyler's bedroom?
We determined that based off of some documents we found in what we believe was Tyler's bedroom, such as mail that was addressed to him, as well as some school documents as well.
And again, in relation to, will you describe the layout of the house in that area?
Yep, so this was on the 2nd floor as you're coming up the stairs. If you turn, coming up the stairs, if you left up the stairs, you're going to run into 2 bedrooms, and that is on the south end of that residence. The southeast bedroom would be Tyler's, and then the southwest would be the spare bedroom. Again, if you go back to the stairs and you make a right-hand turn, that is where you're now on the north end of that residence, and that is now Twiggs' bedroom.
And where were these items here in 23 found?
These were found on the southwest, or in the southwest bedroom, the one right next to Tyler's bedroom.
And you said on top of a safe?
Yes.
Okay. All right. Will you describe what we're looking at in Exhibit 23?
Exhibit 23 are the 5 cartridge casings we found on top of the safe. All were 30-06 Springfield caliber, and one of them had an engraving that said "test shot" on it.
You've talked about Springfield, Remington. Are these these 30-06s? Are they the same type of round as was found in the gun?
Yes.
All right. Did you find any 30-06 weapons in that house?
No, we did not.
All right. Did you search the closet on the 1st floor?
Yes, I did.
What did you find in the closet?
In the closet, we found on the ground some shooting targets with perforations in it, as well as on the shelf, we found a Dremel tool with bits container.
All right, a Dremel tool with bits. What is a Dremel tool?
It's basically like a handheld device where you can make etchings or engravings on things.
What are bits?
Bits would be I guess like a sharp edge or something that would actually cause the etchings that you would put into the tool.
Is this kind of like a drill bit?
Yes.
And what did you do with the Dremel and the bits?
We photographed them in place, took additional pictures, packaged them, then sent them for testing to the ATF.
All right, you also mentioned targets. Were those targets photographed?
Yes, they were.
I want to show you on your end. Have you reviewed Plaintiff's Exhibit 25 before?
Yes.
And is that an accurate photograph of those targets that you found?
Yes.
I move the admission of State's Exhibit 25.
Mr. Burt?
No further objections?
All right, I note the standing objection, and those objections are overruled.
And
Stacy,
excuse me, sorry.
oh, well, did you want to, in regards to publication?
Yes, I'm so used to admission before publishing. I would move to publish those at all three levels.
Any further comment, Mr. Burt?
No further objections.
Again, all right, noting the standing objections, those are overruled. State's Exhibit 25 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
Will you describe what we're looking at here?
Yeah, so these were shooting targets we found in the closet, and each of them have have perforations in them.
You say perforations, what do you mean?
Holes in them.
Those holes consistent with?
Objection, foundation on this opinion.
Mr. McBride, do you want to weigh in upon that objection?
No, I'll submit it. I'll lay foundation if the objection is sustained.
I'll sustain the objection.
All right. Holes. Have you ever shot a gun before?
Yes, I have.
When you hit a target, what happens to the target when it's hit with a bullet?
Hit with a bullet, there's holes in it, what we call perforations, because there's an entrance as well as an exit.
Looking at State's Exhibit 25, I'm going to ask the question that was objected to. You said there's perforations in those. Are those consistent with bullet holes?
Yes.
And I would ask you to describe where those perforations are there's three targets here, right?
Yes.
Let's look at the far right target first. Where are the perforations in relation to the bullseye?
They're all probably within the 7, 6, and 8 ring.
Is there a perforation up at the upper left-hand corner of that rightmost target?
Yes, there is.
Do any of those hit the bullseye?
No.
Okay, looking at the center target, will you describe where the perforations are in relation to the bullseye there?
It's closer, but still not it. Most of them are to the left of the bullseye in rings, let's say 9 and 8.
All right, and then the leftmost target, will you describe where the perforations are there?
Yeah. The perforations are actually closer to the bullseye as well, actually one being in it.
All right, you described also collecting a burnt note. We can take down 25. Thank you. Will you describe where that note was found and what it looked like to you?
Yeah, the burnt note was found in the trash can located in the kitchen. The way it looked like to me, it looked like, say you're at like a campfire and someone burns paper.
What was done with that?
That was also collected, and that was sent to the FBI for analysis.
Was it photographed?
Yes, it was.
And have you reviewed State's Exhibit 24?
Yes.
Is that a photograph of the note?
Yes.
I move the admission of Plaintiff's Exhibit 24.
Mr. Burt?
No further objections.
All right, and to publication?
I move to publish at all three levels.
All right, I'm going to note the standing objection by defense, overrule those objections. And State's Exhibit 24 is admitted into evidence and may be published in the courtroom and may be captured by the media camera.
Do you see here on the screen Plaintiff's Exhibit 24?
Yes, I do.
It looks like as to the evidence tag, it's actually upside down. Is that right?
Yes.
Is there any, does it look like there's any writings on that note, on that burnt paper?
Yes.
Will you point that out for the judge where the writing is?
Yep.
And describe what you're pointing at, kind of the general location on the image?
Yeah. So the part that I'm pointing out is the paper that you can still see the lines in them, and as well as some handwriting as well to the edge, the left edge of that piece of paper.
All right. Have you also observed the image of a note that was recovered from Lance Twiggs' phone?
Yes.
And I'd like to show you side by side Exhibit 24. And there on the left, you see Exhibit, well, that's good. There on the left, we see Exhibit 24. Do you see that?
Yes, I do.
And on the right, you see, excuse me, on the right is 24, on the left it's 16.
Let me stop you, Mr. McBride. I'm not sure, is this being broadcast?
Let's take that down.
All right.
Exhibit 24, thank you, Your Honor. Excuse me, Exhibit 16.3. I would move to publish Exhibit 16.3 and 24 side by side. I think they're currently on the council monitors.
So 16.3 has already been admitted.
And I don't remember the court's order if this was to be captured by electronic media or not.
No, it was not.
Okay.
Is that does that comport with defense's memory as well?
It does.
All right. So 16.3 was published to the courtroom, but not to be captured by the media. So
Very well.
as it's, and what is your request?
To comply with the court's order.
All right. So 16.3 and Exhibit 24 may be published side by side only to the courtroom itself, but not on to be captured by the camera. Also acknowledging that the magistrate can weigh the evidence and is not weighing in on this evidence, solely admitting it. Well, it's already been admitted, but as it relates to the testimony, the court is going to overrule the objection and allow the testimony to be given. Again, whether the court accepts or doesn't accept that will be a determination made when determining probable cause.
Thank you. Do you see any consistencies that you're able to look at? Did you also collect the defendant's car?
Yes.
Where did you collect that from?
That was collected at the Robinsons' parents' home.
And will you describe that vehicle?
Yep, that vehicle is say a gray-colored Dodge Challenger.
All right. You've mentioned that you sent several items to the ATF and the FBI for testing. And did you receive reports back from both of those entities with results of their testing?
Yes, I did.
I'd like to show you on the witness's screen only right now, or counsel's screens, Exhibit 30.
All right, while you're doing that, Mr. McBride, and also, could we go ahead and take down State's Exhibit 35? I know it's just in the background, but just to be consistent on displaying of exhibits. All right, thank you. You may proceed.
Plaintiff's Exhibit 30. Do you know what this is?
Yes, this is the ATF report that I received regarding the DNA testing on the gun and cartridge casings. Or sorry, correction, cartridge case and cartridges.
Thank you. And is this in the same condition as it was when you received it?
Yes.
Your Honor, I'd move the admission of Exhibit 30.
No further objections, Your Honor.
All right. I note the standing objections, and as to publication, Mr. McBride.
Yes, Your Honor. This exhibit deals with DNA testing on the rifle and the cartridges. We would move to have it published at all three levels.
All right. So noting the standing objection by defense, I'm going to overrule that objection pursuant to Utah Rule of Evidence 1102. State's exhibits, and this is 30?
30.
State's Exhibit 30 is admitted into evidence and may be published on screen in the courtroom and for the media camera.
I want to ask you a little bit about the format because it may be helpful to understand here. But on page 1 under the exhibits, we have here a list of items that were sent in for testing and comparison. Is that right?
Yes.
And throughout the report refers to the items compared by the lab number. Is that right?
Yes.
So if we can scroll down just to the bottom of this first page, and here in the DNA analysis section, again, we see that the report or the author refers to the items by their exhibits numbers, right?
Yes.
Okay. And if we can go to page 2. And same question here. The exhibit number on the left, if we want to know what exhibit number that is, we have to refer back to page 1 for the description, right?
Yes.
Okay. And let's keep going to page 3. If we can just scroll through page 3, 4, and land on page 5. Actually, pause right there, if you will. This is page 4. There's a description section here as well. And that description talks about where the swabbing that's used to compare what was swabbed for the comparison. Is that right?
Yes.
Okay. Let's go to page 5. So as we look at this first paragraph here under statistical analysis, let's see if you have this notated or no. Exhibits 1.1 and 1.4. Do you know what that is referring to?
Yep, they're referring to 1.1 is swabs of the stock and grips of the rifle, and then 1.4 is swabs of the bolt of the rifle with possible ridge detail and or smudging.
Okay. Will you read paragraph D?
Yes. The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson, Exhibit 7.1, as a contributor to the major components and 3 unrelated unknown individuals than if they originated from 4 unrelated unknown individuals.
And again, that's swabs of the grips and the bolt. Stock and grips and bolt, is that right?
Yes.
Okay. Number 2, calculation number 2. Where is this swab taken from?
Exhibit 1.2 would be swabs of the butt plate of the rifle.
And will you read paragraph D here?
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 4 unrelated unknown individuals than if it originated from 5 unrelated unknown individuals.
Looking at calculation number 3, exhibit 1.3, what areas were swabbed for this comparison?
1.3 is swabs of the trigger and trigger guard of the rifle with possible ridge detail and or smudging.
We read paragraph D.
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
If we can go to page 6. Calculation number 4, exhibits 1.5 and 5.1. What are those?
Sorry. 1.5 are swabs of the forend of the rifle, and 5.1 is swabs of 1 .30-06 cartridge.
And again, that cartridge came from where?
From the firearm.
Will you read paragraph D?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
All right, let's look at calculation number 5, 1.6 and 3.1. What are those?
1.6 is swabs of the barrel of the rifle with possible ridge detail and or smudging, and 3.1 is swabs of 1 .30-06 cartridge.
And that .30-06 cartridge came from where?
From the firearm.
We read paragraph D.
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as a contributor to the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
Okay, statistical analysis calculation number 6, exhibit 1.9. Where is that from?
1.9 is the swabs of possible ridge detail and or smudging on the optical accessory of the rifle.
Is that a scope?
Yes.
Okay. Will you read paragraph D?
The DNA profile is 6.28 billion times more likely if it originated from Tyler Robinson as a contributor to the major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
Okay. On number 7, I'm not going to read that. I think we've gone through this enough. That's the last one in this report. Is that correct?
Yes.
All right. We can go to Exhibit 32. 31 was previously received. And just display this on the screen of the witness, please. I think it might display on the gallery video, okay. All right, thank you. Can you see Exhibit 32 on your screen, Agent Baumann?
Yes.
What is this?
This is an ATF report that I received in relation to the gun as well as cartridge case and cartridges.
And is this report in the same condition as it was when you received it?
Yes.
I move the admission of State's Exhibit 32.
So question for you, was this the report that was previously disclosed in one of the early motions?
Yes.
All right. All right. To Mr. Burtz.
No further objections, Your Honor.
All right. And for publication level?
All 3 levels.
All right. As it relates to State's Exhibit 32, is accepted into evidence, may be published in the gallery as well as electronic. The media camera can capture it. And I note that this has been previously disclosed publicly from an earlier filing, I believe from either late last year or early this year. So for those reasons, it's accepted into evidence and may be published at all levels.
Your Honor, it's 2:30. I probably have 10 more minutes. Would you like to take a recess now or after I finish?
Let's just do the 10 minutes.
Okay. All right, Exhibit 32 is in front of you. And what was being analyzed in this test?
What was being analyzed would have been the cartridge case as well as the bullet fragment and the lead fragments that were recovered from Mr. Kirk at autopsy.
Right. Same question on structure of the exhibit. The lab numbers and agency numbers are listed here on the first page, right?
Yes.
And if you want to know what the report is talking about, you have to refer back to there, right?
Yes.
All right. I want to have you read, if you can scroll down to the bottom of page 1. Thank you. I would ask you to read the second line under results of examination.
Yes. The Exhibit 1 rifle was test fired and found to be in operable condition. The test fires were designated as Exhibit 1.11.
And again, Exhibit 1 rifle is what?
Is the one that we found on campus.
Okay. Exhibit 2, if you'll look at the next, skip the next line and then go to the Exhibit 2 cartridge case, will you read that sentence?
Yes. The Exhibit 2 cartridge case was identified as having been fired in the Exhibit 1 rifle.
Okay, now I want to jump back up to the top where it lists the exhibits. 2 through 5, will you explain what those are and where they came from?
Yes. That would be the items we found in the gun on scene, and this was the gun that was found in the wooded area.
And so the cartridge case is the round that had been, is the case that had been fired?
Yes.
Okay, so that's number 2. All right. I can't remember. Did we already read that line? Exhibit 2, cartridge case?
Yes.
Okay, thank you. Will you also look at or read the last paragraph on this page?
Yes. The Exhibit 2 cartridge case and Exhibit 3 through 5 cartridges were examined for the presence of comparable tool marks. Tool marks were located on the exterior of the Exhibit 2 cartridge case and Exhibit 3 cartridges, in parentheses scribe marks, that are consistent with being produced by engravings and or rotary cutting tips commonly found.
Let's scroll down, please, Kimberly.
Installed in handheld rotary tools, such as a Dremel tool. These tool marks contain marks of value for comparison if a suspect tool is located.
Okay. I'd ask to scroll back up to show the exhibit list. Number 6. What is Exhibit 6?
Exhibit 6 is the bullet fragment, the bullet jacket fragment, as well as some other fragments that were recovered from Mr. Kirk at the time of autopsy.
Thank you. Going back to page 2, will you read the first full paragraph there, beginning with Exhibit 6?
Yes. Exhibit 6 consists of one .30 caliber class deformed damaged bullet jacket fragment and 4 lead fragments.
Will you read the next paragraph as well?
The Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1 rifle based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The results of the comparison was inconclusive.
And if you'll look at the line starting with the Exhibit 6B through 6E, will you read that sentence as well?
The Exhibit 6B through 6E lead fragments are not suitable for microscopic comparison.
Thank you. We can take Exhibit 32 down. Exhibit 33, if we can show that just to the witness, please. You recognize Exhibit 33?
Yes.
What is that?
This is an ATF biology report on the Dremel tool as well as the cartridge cases that were found on top of the safe in Tyler's home.
Did you receive this from the ATF in response to your request for testing?
Yes, I did.
I move the admission of State's Exhibit 33.
No further objections, Your Honor.
Thank you, Mr. Burtz. Noting the standing objections by defense and level of publication, Mr. McBride.
All three levels.
Court overrules the standing objections and State's Exhibit 33 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
What was being tested here?
The Dremel tool, the bits container, as well as the cartridges and cartridge casings we found in Tyler's home.
And up in the top right, it says forensic biology. Is this DNA testing?
Yes, it is.
Okay, format of this is the same as the other report that we already looked at, right?
Yes.
Let's jump to page 4. Calculation number 1. It mentions here Exhibit 15.1. Do you know where that swab is from?
Yep, it is swabs of the buttons of the Dremel tool.
And will you read paragraph D?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a contributor to the major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
We also read paragraph E.
The probability of an unrelated individual in the population who has not contributed DNA to this sample yielding this level of support is less than 1 in 1 trillion.
Thank you. I'm not going to ask you to read those paragraphs for the rest of the statistical calculations, but I will ask you to go through and identify where the swabbing came from. Exhibit 15.3, which is calculation number 2, where's that swab from?
As swabs of the cord of the Dremel tool.
Exhibit 15.5.
That would be swabs of the longest metal bit of the tool.
Going on to page 5. Calculation number 4, exhibit 15.6.
15.6 is swabs of the shortest metal bit.
And calculation number 5, 18.1.
This is swabs of one etched 30-06 cartridge case
What is that? Where did that come from?
that come from on top of the safe.
Okay. Is that the one that had the etching test shot?
Yes.
Will you read the paragraph D as it relates to the test shot swab?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
Thank you. We can take Exhibit 33 down. The final report is 34, if we can publish that just to the witness. What is State's Exhibit 34?
This is an ATF report I received that was comparing tool marks.
And is this, I move the admission of Plaintiff's Exhibit 34 and publication at all 3 levels.
Mr. Burt.
No further objections.
All right. And, all right, so State's Exhibit 34 is admitted. The objections, the standing objections by defense are overruled. They may be published in the courtroom and captured by the media camera.
Okay, looking at the exhibits, might have to go back and forth here, but let's go to page 2. And will you read the paragraph that starts with Exhibit 18 consists?
Yes. Exhibit 18 consists of 5 30-06 Springfield caliber fired cartridge cases, designated Exhibits 18A through 18E, and 15 45 auto caliber unfired cartridges, designated Exhibits 18F through 18T.
Okay. 18A, do you know what 18A is?
Yes, this would have been the 30-06 cartridge case with the engravings test shot on it.
Okay. Will you read the paragraph beginning with the Exhibit 18A?
The Exhibit 18A cartridge case was examined for the presence of comparable tool marks. Numerous sets of tool marks were located on the exterior of the Exhibit 18A cartridge case that are consistent with being produced by engravings and or rotary cutting tips commonly found installed in handheld rotary tools, such as a Dremel tool. These tool marks contain marks of value for comparison.
Okay. The next paragraph I asked you to read is the one that starts with Exhibit 16. But first I want to ask you, do you know what Exhibit 16 is?
I do not, off the top of my head.
Okay. 18, it also says Exhibit 18A through 18E. Do you know what those are?
18A through 18E would be the cartridge cases that were found on top of the safe.
Okay. If you'll read paragraph, or that paragraph.
Which one again, sorry?
The one starting in Exhibit 16 and.
Yes. The Exhibit 16 and Exhibit 18A through 18E cartridge cases were identified as having been fired in the Exhibit 1 rifle.
Okay. Let's now jump to the paragraph beginning, the test tool marks. Kimberly, if we could scroll down. Will you please, well, first off, 15A and 15B, do you know what those are?
Yes, those would be the longest metal bit and then the shortest metal bit.
Okay. If you would read, okay, and then also Exhibits 2, the Exhibit 2 cartridge case, what is that?
This would have been the cartridge case that was found in the gun.
And Exhibits 3, 4, and 5 cartridges?
They were the ones also found in the gun.
And Exhibit 18A?
Is the one that was found on the safe.
Okay. If you'll read the first bullet point there, the Exhibit 15A.
Yes. The Exhibit 15A engraving cutter was identified as having made tool marks located on the Exhibit 2 cartridge case, Exhibit 3 through 5 cartridges, and Exhibit 18A cartridge case.
And will you, Okay. We can go ahead and take that down. Your Honor, I want to, before I ask to enter my final line of questioning, I would like to show the witness exhibit 12.1, and this is the video, the UVU surveillance video. Let's see, I think it's 12.4 was the surveillance video actually that was approved for publication.
That's correct. That's the
And-
unmarked, non-zoomed version, correct?
Is that correct? Yes.
Yes, that's the one that, yes.
And just for now, let's do this on the witness's screen. .4, and I'll ask you to jump to the 804 mark. Okay. I'd move to publish, we intend to play about 10 seconds of this video. I'd move to publish that at all 3 levels.
Mr. Burt?
I'm not sure what the relevance is at this point, so it's hard to object or not. I would ask for a proffer as to what it's showing, because it's not apparent from the exhibit.
Understood. Proffer is, there's been testimony about about prints being found on the glass window of this building. This exhibit demonstrates the suspect's behavior in that area.
All right. Anything further?
Would that, I don't have any further objections.
All right. So it may be published. This is already admitted, and it may be published at all levels.
Okay, before you pause, before you hit play here, Sergeant Falmuina, do you see what's on the screen in front of you?
Yes, I do.
Can you see the suspect in this image?
Yes.
Will you describe where that suspect is?
He's on the rooftop, let's say on the gravel part, and this would have been close to the northeast side of that building.
Timestamp is 12:23:47 p.m., is that right?
Yes.
And that portion of the image that we see there, the video, is the top portion of the image slightly to the left of center, is that right?
Yes.
Okay, we're at 8:01. Kimberly, will you please hit play there? Let's go ahead and pause it. Pausing it at 8:20. Were you able to determine if the suspect touched the glass when he dropped from the roof?
Not at the time when we first saw the video, no.
Okay. Were you later able to make any determination on that?
Yes, because the video we had was pretty grainy at the time at the command post, and it wasn't until we're actually able to get the footage directly from UVU.
And when you actually got that footage, could you zoom in and get a better picture?
Yes.
And were you able to determine at that time whether the suspect touched the window?
Yes.
What was your determination?
We determined that he was not, or he did not touch it.
Thank you. Nothing else.
All right. Let's go to a break. To defense, I realize that you began talking about your concerns. You have a witness that needs to leave today. 10, 15 minutes, what's your request? I want to maximize your ability to have time with your witnesses as well as cross if you choose to.
Thank you. Just 10 minutes would be fine.
All right, let's break for 10 minutes and then come back and cross-examination. Court is in recess. Please be seated. Court is back in session. Noting the presence of all parties, we just ended with a direct examination of the sergeant. Turning to defense, Mr. Burt,
Thank
your
you.
witness.
Good afternoon.
Good afternoon.
Your role in the case was kind of as the traffic manager of the whole operation, right?
That's a good way to put it, yeah.
And we're talking about multiple agencies besides the SBI, correct?
Yes.
Your agency, if I'm correct, wrote a massive report, 229 pages long.
Yes.
You've read that, you're familiar with it?
With most of them, yes.
Okay, and it's a compilation, right? You authored some reports, but a lot of other people wrote reports about aspects of the investigation.
Yes.
And as those reports were getting done, you would kind of read them and decide what needed to get done further?
Yes.
Was that one of the roles that you performed in this case?
Yes, as well as consulting with the case agents.
Okay. Now, if my count is correct, 9 of those reports in that larger body of reports was written by you, correct?
Yes.
Did I miss any? Does that sound about right?
Yeah.
Okay. I want to ask you about a couple of those reports. The first report was a report that you wrote on September 22nd that documented the overview of the crime scenes, correct?
Yes.
And there were various crime scenes that you've described on direct examination, correct?
Yes.
One of them was the Fulton Library.
Yes.
Tell us why that was a potential crime scene.
Yeah, of course. When officers were canvassing the scene, they were also trying to see, right, the route of the shooter as well as just trying to find the shooter. And they determined that the Fulton Library stood out because there were unattended items there at the bus stops that were away from the courtyard area, and so to them they thought it was suspicious.
And were certain items seized from, and what were they?
Yes, you had a backpack, a jacket, as well as some gloves, and there may have been some other things. I just don't recall them right now.
And do you recall what the item numbers were of those seizures? Was it 9? Does that ring a bell?
I don't remember.
Whatever was seized was sent to the FBI lab for processing?
Yes.
And along with some information that the suspect may have shed some of these items as he fled, correct?
Yes.
Was a decision at some time made, and you were requesting that both DNA and other type of analysis get done?
Yes.
At some point, did you decide to pull a plug on that?
At the time when it was already sent, we didn't have more information as far as whether or not the evidence that were collected there were probative.
But eventually you communicated to the lab that those items were not in fact connected with the case and there was no need to do further testing.
I don't remember communicating that.
Okay. If that's in the notes of the FBI or the ATF, would that be inconsistent with what you know?
No.
Okay. I mention it because some of the reports, the lab reports, have those items listed.
Okay.
I just want to be clear that those items eventually you determined were not related to this case. Would that be fair?
Yeah, that would be fair.
Okay. The second report, at least as far as I can see, that you wrote was on September 24th, and it had to do with looks like a request for a search of firearms. Do you recall that?
Could you elaborate for me on the firearms?
This document documents the NIBIN request for firearms.
Yes, so that was the request to conduct. What that stands for, the NIBIN, is the National Integrated Ballistics Information Network. It is run by the ATF, and that is where we test or we input test fires or cartridge casings, the head stamps and whatnot, into a machine that is then run through the ATF to see if there's any other cartridge casings that match.
And nothing of value came from that part of your investigation, correct?
Correct.
Now, going back for a minute to the crime scenes, you talked about the wooded area, and you used the phrase, "we seized the towel." Who is we? Who are you referring to when you say we seized the towel?
We would be SBI as well as FBI. So that would be myself as well as FBI Evidence Response Team Lead Michelle Kamak, or Special Agent Michelle Kamak.
So you both reached into the bushes and you both grabbed it and pulled it out?
She did, but I was there with her and we were communicating that entire time.
Okay, so when you say we seized the towel, what you really mean is she seized the towel and you observed her seize it?
Yes.
And when she sees a towel, can you describe a little bit more detail of how that process took place?
As far as when it was found or when she removed it?
Yeah, the photographs you showed us, were those the best photos you've got of that process?
That was taken by the FBI, so that's all we got.
That's all you got. And nobody was videoing the discovery and recovery of that evidence?
I believe one of the officers on scene actually had his body camera on.
And have you seen that?
I have not.
Do you know if there's any documentation of the exact process by which that towel got removed from the rifle and then, I guess, put back on the rifle, right?
No, it was not.
It was not put back on?
No.
Didn't one of the photos show the rifle in the box with a towel over it?
Yes. It wasn't over it. It was still wrapped around the gun.
Okay, but as I understood your testimony, the towel was seized by the FBI agent, and then somebody must have reached in and got the gun out, right?
No, I'll clarify for you. So
Sure.
the entire time when we retrieved it, the gun was wrapped in the towel. So when Special Agent Kamak reached in, she grabbed not only the towel but also the gun, and it remained, and the towel and the gun remained basically intact, lack of a better word, and then was placed onto the cardboard box, which is one of the photos that was shown earlier. Once we documented that, and then the towel was removed from the gun.
You also mentioned as to the other crime scenes that we processed it, but was your role in terms of your actual participation limited to the wooded area? Or were you involved in actually seizing evidence at the other locations, like the roof?
Yeah, I was involved in coordinating all that, and then determining from there where the evidence would go.
Involved in, is that the same thing as actually being on the roof and seizing the items? Or are we talking about something else?
Talking about something else.
And what is that something
So
else?
after the teams would have packaged all the items, sealed them properly, created an evidence log, they will then bring it back to the command post, and from there we would compile everything, and then there was a discussion that was had as to who would take custody.
Fair to say that you did not observe yourself the seizure of the screwdriver from the roof?
Correct.
And who were the people who were actually conducting that part of the crime scene processing?
That would have been our state crime lab, those two people are part of our state crime lab's crime scene response team.
When did you review the video of the suspect running toward the area from which he jumped off?
That would have been, I don't know the exact time, but it would have been the day on September 10th.
You saw that on September 10th?
Yes.
And when were the windows processed for the latent fingerprints?
The windows were processed on September 11th, the next day.
And was the reason that those latent lifts were taken was because you wanted to rule out whether the suspect had touched that window?
Yes.
That's what the notes say, right?
Yes.
You were not present when that scene was processed either, correct?
Not the entire time, no.
Okay. Now, the other reports that I have that you did, and correct me if I'm wrong, is one report dated September 24th, documenting the forensic analysis as of September 24th, summarizing what you were hearing back from the ATF and the FBI.
Yes.
Okay. And then the fifth report was again about the crime scene progress of the forensic testing, right?
Yes.
Right. And then you have a report here which documents a firearm trace and a firearm seized at River River Street.
Yes,
Nothing of value came of that, correct?
correct.
You have a report that has to do with the latent print report from your people, SBI.
Yes, it's not SBI, it's actually the State Crime Lab, but yes, same department.
Same department. Just detailing the results of that examination, which the stipulation addressed,
Yes,
right? You have a report documenting the transfer of evidence from the FBI to your department.
yes,
And then the last one that I have that you personally wrote has to do with again, summarizing forensic reports.
yes,
Okay. The larger 229-page report indicates that there was some investigation done by your agency that involved interviewing associates of Mr. Robinson to see if you could develop some profile of him having animosity toward Mr. Kirk, correct?
I'm not familiar with that.
So you weren't involved in that at all?
No.
Some of the documents in that large report indicates that your agency has also, up to the present time, been monitoring Mr. Robinson's mail and communications at the. And have you kept abreast of that investigation?
No.
Do you know whether anything of value has been developed as a result of that?
No.
That's all I have. Thank you.
Thank you, Mr. Byrd. Redirect? All right, may this witness be excused? All right, Sergeant, thank you.
Thank you.
Turning to the state.
Your Honor, I just want to confirm with the clerk that
Yeah, let's make sure, thank you, Mr. Gernander, appreciate creating a good record.
Judge, if I could just confirm with the court that all of the exhibits we have offered have been admitted into evidence.
All right, so here's what I have, and my court clerk will certainly correct me if I'm wrong. I have State's Exhibit 1, 2, 3, 3.1, 3.2, 4, 5, 5.16, 6.17, 7.18, 8.19, 10, 10.1, 10.2, 10.3, 11, 12.1, 12.2, 12.3, and I believe 12.4, 13, 14, 15, 16, 16.1, 16.2, 16.3, 16.4, 17 and 18 are blank, so no.
That is
19
correct.
All right.
We're not offering 17 and 18.
All right. 19, 20, 21, 22, 23, 24, 25. The following are blank, 26, 27, 28, 29.
That's accurate. We're not offering on those numbers.
I have 30, 31, 32, 33, 34, and 35, which have been admitted into evidence.
That is all that I have record of.
All right.
Can I-
Does that comport?
Yes, can we also go over the ones that were
I mean, we certainly can. Yes, would you like to put on the record what were published and what were not published?
No, that's okay, Judge.
Okay, we're good. And then, all right,
Can I have just a moment?
yes.
Your Honor, the state rests its case in chief.
Thank you. Turning to defense. Approach the bench, please. get situated. All right, counsel, your request.
Your Honor, as the court knows, the family has asked that all exhibits admitted into evidence be shown here in open court. We are grateful to the court for allowing the family to view many or most of the exhibits today that were admitted. They were viewed here openly in court. And obviously that was done after the court struck what we think is the appropriate balance after a very thoughtful and thorough analysis. I'm going to ask the court to reconsider one of its prior rulings. I understand reconsideration is always a big ask, but I do think, Your Honor, that if the court were to display publicly, or just in the courtroom, Exhibit 12.1, which is the enhanced video, version 12.4, which was played in court, was very hard for the family to view. We think that, we asked the court, that since the court's considering it, that the family should be able to view it as well. When conducting the appropriate balancing, the court, as the court knows, can alleviate any concerns about proper jury selection with certain tools at its disposal. However, if the court were to deny the family the right to view that video, there's no cure. It's either they get to view it or they don't. So we would ask the court to reconsider its prior ruling and to display just in the courtroom Exhibit 12.1, which is the enhanced video. Thank you, Your Honor.
Thank you. Turning to the parties, starting with the state, Mr. Grunander.
Thank you, Judge. The state does not oppose publishing 12.4 in the courtroom. I think we've tried to make it very clear throughout this case that we favor openness and transparency as much as appropriate. I'll submit it on that.
Thank you, Mr. Grunander. To defense, Mr. Burt.
My apologies, that's 12.1, not 12.4.
Thank you.
Judge, at this point in the proceeding, we're asking the court to keep focus on the purpose of this hearing. And as the justice has said in the Estes case, the purpose of a trial, and I know this isn't a trial, but the same logic applies, is to determine the defendant's guilt. It's not to educate the public or the victim's family or the world on what evidence the government or the state has. As the court knows, we have witness availability problems. We spent the bulk of today and yesterday arguing about nothing to do with the evidence in the case, but with rights of third parties. And it's appropriate for the court to consider that, but at some point, I think the court has to return to the purpose of these hearings, which is to expeditiously hear the evidence and then determine probable cause. And I want to point out to the court, Ms. Kirk has been very adept at holding press conferences at which she has revealed evidence. She has represented that the state is her attorney. She has access to all the evidence that the state has publicized and that the media and her own lawyer argues is already in the public domain. So they're perfectly free to go outside this courtroom under the court's protective order. They're free to go out and hold press conferences and announce to the world outside the courtroom what they think the evidence is. They have the availability of that evidence. But the court's role, I think, at some point is to exercise some control, move the case forward, and especially when we have witness availability problems. And I'd ask the court, whatever the court does, if you're going to allow revisiting or replaying of evidence for the sole purpose of informing the world or Ms. Kirk or anybody else, that the court do it at the end of the process and not at this point where we will be deprived of our ability to call this witness, because she has to be done today.
Thank you, Mr. Byrd.
Thank you.
Briefly, and I say that because time is of the essence, not because I don't want to hear what you have to say.
I understand, but there was a lot that was just said that's just not true.
Well, so let me put this in a spot where we need to be. And I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth about issues that lie outside of probable cause. And I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family has not seen this video. It hasn't. It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. There's a completely distortion of reality that was just put forth. And this isn't about educating anybody about anything. This is about allowing the family to see the evidence that's been gathered after a 10-month investigation in which a father, a husband was assassinated. That's what this is about. So we ask you to please allow the family to view the video like the court has viewed in order to allow the family to process this moment.
Thank you.
Thank you.
Anything further before the court issues its ruling and we go from there?
Not from the state.
All right. Defense?
No.
All right. All right. So I recognize that the Utah Constitution under Article 1, Section 28 recognizes victims' rights, and the court respects those rights, and as has been previously stated, balances those rights with the constitutional rights of all parties. I will reserve my ruling on that and maybe revisit it tomorrow. But because we have an issue of expiring time and one witness that needs to leave today, I need to turn to that. I'm not ruling that that cannot happen, but for today, we need to focus on this to getting this defense witness on the stand and off the stand. And so please, if I do not remember, the parties can remind me and we can revisit this tomorrow. So again, I'm not saying yes, I'm not saying no, I'm simply saying we need to get to this witness, and I'm happy to readdress this tomorrow. Okay? All right. Mr. Burt. All right, Samantha Carner is being requested. If you can go ahead and retrieve her, bring her into the courtroom.
Someone's doing that.
Is somebody grabbing her?
Yes.
Okay, thank you, Mr. Burt. I just couldn't tell and wanted to make sure. All right, Ms. Carter, if you wouldn't mind coming forward, right by our bailiff to be sworn in.
Please raise your hand. Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. You can sit
All right, thank you, ma'am. If you wouldn't mind coming forward, having a seat at the witness stand. To your left is a water bottle if you choose. It looks like you brought your own as well. And after you're situated, if you wouldn't mind pulling that microphone toward you, just to ensure that your testimony is picked up on the record. Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Carner.
And Ms. Carner, what do you do for a living?
I am a firearm and toolmark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there? What area of expertise do you have?
I am assigned to the firearm and toolmark unit, so I receive items of evidence related to firearms, tools, toolmarks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
Do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens, it's admitted and
Okay.
I think approved.
All right,
for
let's go ahead and put
publication.
it on all screens because this was admitted and published previously. All right.
You recognize plaintiff's exhibit number 32?
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the Submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a tool mark characterization on the cartridge case and the cartridges, and then I also ran a general rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page. Those 2 paragraphs, please. Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes.
Is this the ATS, is this a language referred to in your report?
It is, yes.
The written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm tool mark discipline pattern examination?
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11.
All right, and what level of publication are you requesting, Mr. Birds?
Both public and admittance into evidence.
To this date?
No objection.
All right, Carner 11 is admitted into evidence and may be published on screens and captured by the camera.
Thank you. And you can publish that? Ms. Carner, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report, and it standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head, no.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says qualifications and limitation of firearm tool mark discipline examination. You're familiar with that part of the policy, correct?
I am, yes.
And the portion of the policy that says a conclusion provided during testimony or in a report is ultimately an examiner's decision and is not based on a statistically derived or verified measurement or comparison to all other firearms or tool marks. Therefore, an examiner shall not, and then it lists several propositions. You're familiar with that language?
I am, yes.
And it says that an examiner shall not assert that a source identification or a source exclusion conclusion is based on uniqueness of an item of evidence. Your report is not meant to imply something contrary to what's stated here, is it?
No, it's not meant to contract.
You're not asserting that a source identification is based on the uniqueness of an item of evidence.
No, I am not.
And the reason you're not doing that is because you haven't examined all possible items of evidence that could be relevant to your comparisons, correct?
I have not looked at every firearm that's been manufactured in the world, nor have I looked at every tool that's been manufactured in the world. That's correct.
Okay. The second portion of that says an examiner shall not use the term individualize or individualization when describing a source conclusion. Did you abide by that policy in this case?
I did, yes.
And you're not expressing an opinion here that the comparisons that you made, a particular weapon or a particular cartridge case, correct?
My conclusion for one of the exhibits identifies the cartridge case as being fired in the firearm, but that's all it says, yes.
Right, but you're not asserting that that's an individualized identification in the sense that's being used in this policy, are you?
No, I am not.
Okay, and then the third part of that says that an examiner shall not assert that two tool marks originated from the same source to the exclusion of all other sources. You're not expressing that opinion either, are you?
I am not, no.
It says an examiner shall not assert that examinations conducted in the forensic firearms tool mark discipline are infallible. You're not asserting that?
I am not, no.
You're not asserting that, it says the examiner shall not assert that there is a 0 error rate. You're not making that assertion?
No.
Okay. Says an examiner shall not provide a conclusion that includes a statistic or numerical degree of probability except when based on relevant and appropriate data. You didn't conduct such an analysis here, correct?
I did not, no.
Okay. And it says an examiner shall not cite the number of examinations conducted in the forensic firearm tool mark discipline performed in his or her career as a direct measure for the accuracy of a conclusion provided. You didn't do that and you're not doing that here, correct?
Correct.
And then it says, an examiner shall not assert that two tool marks originated from the same source with absolute or 100% certainty, or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony, unless required to do so by a judge. You're not making any such assertions in this case, are you?
I am not.
Okay. All right, thank you. You can take that down. Now, when you conducted your analysis in this case, and in all cases, do you typically generate a case file that includes proper documentation of your examination?
I do, yes.
And did you do that in this case?
I did.
Could you display to her alone, please, Exhibit 6, Carner 6? Case file. Yes. Do you see what's displayed there?
I do, yes.
It's a 47-page. Is this your case file?
It is, yes.
Did you rely on the documents and photographs that are documented here in writing the report that the state introduced into evidence here?
How so?
Before you wrote your report, did you photograph items that you were looking at, take other notes, and then use that work product to form the opinions you reached that are documented in the report?
The notes are mostly used for initial documentation and evaluation, and then, yes, supplement to the conclusions that I make. It's all a representative image of what my conclusions are going to be. So part of it is going into the conclusion statement and then just showing proof of those conclusions.
Right, and your standard operating procedure requires that you document in your case file the basis for your opinions, correct?
Yes.
I'd move Carner 6 into evidence.
To the state.
Is this the 47-page document?
Yes.
I object. I don't see the relevance to the court's probable cause determination to review a 46-page report that includes notes.
Would you like to respond, Mr. Burt?
Yes, Your Honor. This is the basis and documentation of the conclusions reached in the expert's brief report, which expresses her ultimate conclusion, but does not contain any of the reasoning for that conclusion. So it's important for the court, I think, to understand why and how she reached the conclusions that she did.
All right. Anything further?
No?
Yes, just that without testimony about what the meaning of the notes is and so forth, it is more confusing than it is probative. So under a 403 analysis, I don't think it's admissible nor helpful to the state, to the court.
All right. Mr. Bird?
I intend to focus on particular photographs which document what she received in evidence and the comparisons that she did, which are also documented in this file in the way of comparison photographs.
All right. As it relates to the objection is overruled. I find that this is relevant as it relates to State's Exhibit 30, which was admitted, as well as State's Exhibit 32, which is admitted, and the state is able to do cross-examination on this witness as it relates to this report. And so it is admitted and may be published on all levels in the courtroom and through the media.
Thank you. Ms. Carter, one of the items you were asked to look at was, as described in your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the evidence, it was in a sealed condition, correct?
It was, yes.
And when you opened, what was it, an envelope?
A small individual manila envelope, yes.
And did you take the contents of the envelope containing the bullet and take photographs of it?
I did, yes.
Okay. Could you display page 41 of 47 of that exhibit? I'm sorry, page 14. And tell us what's depicted here.
Yes, this is a picture of the as-received condition of Exhibit 6 in its entirety. That's the top picture. So you'll see Exhibit 6A all the way through 6E in descending order. And then the bottom 2 photos on the left is the Exhibit 6A bullet jacket fragment, and that is the view of the exterior. And then the photograph on the right is the Exhibit 6A bullet jacket fragment, and that's the view of the interior of it.
Okay. Now, after you documented what the bullet and the fragments look like, did you do certain procedures on the bullet, the larger bullet fragment?
I did, yes.
And what did you do?
I cleaned the bullet jacket fragment, and I also peeled the petals back. If you think of a banana and peeling the skin away from the interior, it's almost like doing that. As you can see from the photo, the petals have been crumpled in on themselves. So in order for me to see the land and groove impressions, which holds those individual characteristics needed for a comparison, I have to do some maneuvering of those petals.
And how do you do that? Do you use an instrument to peel back the portions that you want to look at?
I use pliers.
Okay. And after you did that procedure, did you then photograph the larger bullet fragment itself?
I did, yes.
Were the smaller fragments essentially not of any value to you in terms of doing comparisons?
They were deemed unsuitable, which means there are no microscopic marks of value for comparison.
Okay, but the larger fragment, after you did the process you just explained, you then photographed it again, correct?
That is correct, yes.
Could you display the next page of this exhibit, please? Tell us what we see here.
This is 2 pictures of that 6A bullet jacket fragment after the examination preparation. So the top photo is going to be the interior of 6A, and then the bottom photo is the exterior of 6A.
Now, after you took these photographs, did you proceed to do something to determine whether you had either class, individual, or subclass characteristics.
Yes.
Tell the court what that means.
To start, when I do my initial examination of a bullet jacket fragment like this, I'm going to look at its class characteristics. Class characteristics are the least restrictive set of characteristics I use in my comparison process. And these are design features that are given to a large group of items that characterize them together. So for a bullet, you could think of the diameter of the bullet, the number of landing grooves, the direction of twist, and the type of rifling. So I would go through and look at the class characteristics of this bullet jacket fragment, which was 6 right conventional rifling. Then I'd move on to look at any subclass characteristics. And subclass characteristics are more restricted than class, but less than individual. And they are design features that can be put on an object during the manufacturing process, which is consistent among items that are made by a tool that's in a specific state of wear. So what I mean by that is it's going to be a subset of a larger group, which is why it's not used for for identification or comparison purposes for the basis of a conclusion. But when you think of something that's made through a mold process, when that mold comes together, it creates a seam line, and that seam line is going to be represented on all the items that it makes. So that's why you can't use it for the identification process, because it's going to be on a lot of items, which is why it's a subset of the group. Then I move on at looking at the individual characteristics. And these are imperfections and irregularities that arise from the manufacturing process. And then there's also individual characteristics can arise from wear, use, and abuse of a tool. And these individual characteristics is what is going to be distinct to that tool, and that's why they're used for the identification process. So again, I did an examination of its class characteristics, looked for any subclass characteristics, and then looked to see if there was individual characteristics in the land and groove impressions sufficient enough of marks and values to do a comparison process.
Now, once you have the class characteristics of a bullet, can you narrow the range of firearms that could have fired it just based on class characteristics?
You can, yes.
And is caliber a class characteristic or an individual or a subclass characteristic?
It's going to be a class characteristic because a lot of firearms will have the same class, or excuse me, the same caliber.
Did you measure the diameter of the bullet?
I did, yes.
And did you end up with a range where it could have been a certain range of length or diameter?
I did, yes.
And what was your reading?
Can I refer to my notes,
Yes,
please?
please.
The range of the diameter for the 6A bullet jacket fragment was .286 to .301 inches.
Okay, what page are you looking at?
It's page 13.
Okay. Now, so this is your documentation of the diameter measurement. And then on the right there, LIMP, that's measurement of the land width, correct?
The land impression width, yes.
And these are all general characteristics, or class characteristics, right?
Correct.
Okay. Now, once you had that and also that it was, you said, what's called the rifling was to the right, correct?
The direction of twist, yes.
Yeah, the lingo is 6 to the right, meaning.
6 right, yes.
Yeah. And that's a class characteristic.
Correct.
So once you had the diameter of the base of the bullet, and did you have some difficulty because of the damage to the bullet in exactly measuring it?
The reason I provided a range was because of the damage and deformity to the base. So at times it wasn't a perfect circle, so it was important to me to give a range of what those diameter measurements were.
Once you have the diameter and the rifling characteristics and the land and groove measurements, can you then plug those measurements into a database and to narrow down the class of weapons from which this bullet could have been fired?
The general rifling characteristics search will use those class characteristics and will generate a list of possible firearms that could have fired the bullet. But that list is not all-inclusive. It is just used as an investigative tool.
Sure. Could you go to page 47, please? Could you tell us what we're looking at here?
This is the results of that general rifling characteristic, or the GRC search.
All right, and what did you determine in terms of, just based on the class characteristics, what weapons could have fired the 6A bullet?
There were several different .30 caliber class firearms that could have fired the bullet.
And they're listed here, correct?
Correct.
Could you tell us what the initials PI and RI and PR mean in the far right-hand column?
They refer to different types of firearms, so rifles, revolvers, machine guns, any type of firearm.
And what are the pistol ones? How is that designated? PI or?
Correct.
And what is RB?
Bolt action.
Bolt action. So based on the class characteristics, any of these weapons could have fired that bullet?
They could have possibly fired the bullet jacket fragment, yes.
Okay. Now, let's go back to the examination of the other two measures, subclass characteristics and individual characteristics. Is one of the reasons you look at subclass characteristics because they can be confused with individual characteristics?
That is a concern, yes.
In fact, your manual says that, right? It's important to rule in or out subclass characteristics to avoid the danger of confusing them with individual characteristics.
I'm not sure if our manual says it verbatim. It says that we do need to assess every piece of evidence for possible subclass characteristics.
And what is the reason for that?
Subclass characteristics can be similar to individual characteristics. However, trained examiners are able to notice the difference between subclass and individual. Subclass characteristics are not always present on an item. It's possible, but not always present. And they tend to look a certain way. They're going to be uniform in their appearance. They're going to be spaced in a way that's more uniform. If you think of circles, those circles could be a distance between each other in the same distance every time, and they will look almost the exact same every time.
Now, does your laboratory have certain protocols for conducting these comparisons?
We have procedures for comparison, yes, like taking photographs, yes.
Well, but also procedures for instance, you have a document called Examination and Comparison of Unfired and Fired Ammunition and Components that deals specifically with the procedures to be followed for the kind of examination you did here, correct?
Yes, I believe that refers to the minimal documentation necessary for a piece of evidence.
And one of those standard operating procedure requirements is document observations and evaluate for the potential of subclass characteristics on the relevant tool working surface, right?
Correct, yes.
And you did that in this case, correct?
I did, yes.
Okay. And what conclusions did you reach?
Can I refer to my notes,
Yes,
please?
please.
My subclass assessment that's on page 13 of my report states, stria observed in the land and groove impressions contain starts and stops, are not coarse, and vary in their height, width, depth, and spatial arrangement. No apparent subclass influence.
Okay. And what page was that again?
Page 13.
Page 13. Let me ask you about that. The stria observed are not coarse, I think I understand that, and vary in their height, width, depth, and spatial arrangement. Did you measure the height, width, depth of the land and groove impressions?
The land and groove impression widths, yes, I did.
And how about the striae? That's different than the land and groove impression, right?
Correct, yes.
You didn't measure the height, width, and depth of those marks, correct?
No, I did not.
Okay. And your protocol says, does it not, due to their similarity to and potential confusion with individual characteristics, it is essential that the evidence be evaluated for the potential of subclass characteristics.
It does, yes.
That's the whole purpose of why you're doing that part of the exam, right?
Correct, yes.
And anywhere in your protocols, does it specify what you're looking for, or is it just up to you to decide what is and what is not a subclass characteristic?
Subclass characteristics are a very large part of the training process to become a firearm and tool mark examiner. There are modules that are taught where you're trained to recognize what subclass characteristics look like, what manufacturing techniques might lend to more subclass characteristics. So I am trained to know what it looks like.
Okay, and my question though was, does your standard operating procedure set out, here are the things you should be looking for? For instance, does it say, if what the marks you're looking at are not coarse and vary in their height, weight, depth, and spatial arrangement, or if they're perpendicular on the barrel, that indicates that it's not a subclass characteristic. Is there anything like that in the manual?
No, there's not.
Okay. Did you inspect the interior of this barrel?
I did, yes.
And did you notice whether it had any debris or dust in it?
I believe my notes state that debris and dust was observed in the inside of the barrel, yes.
Okay, and could you further characterize what that was? Debris?
I think it says dust, so I would say dust.
What can cause dust to get inside of a barrel?
A plethora of things. I'm not sure why something is ever in a barrel.
Okay. So you determined here, you ruled out subclass characteristics, correct?
Yes.
Then the next part of the examination was determining whether you had any individual characteristics on the bullet, correct?
Yes.
And what did you conclude in that regard?
That there were microscopic marks of value worthy of comparison, or yes, individual characteristics in the landing groove impressions.
And does your standard operating procedure have any guidance in terms of how you go about determining that?
No, I do not believe so.
Okay. And then once you determine that you have items of value on the question bullet, do you then do something to produce test bullets?
Yes, part of the comparison process when there is a firearm that we receive is to test fire it to make pristine samples to see if reproducible individual marks of value is on the bullet or the cartridge cases.
How many test fires did you produce in this case?
I made 3 sets, so 6 total.
6, is that your standard number of test fires?
Our standard operating procedures state that you need at least 2. There is not a maximum number that we are allowed to do. It's the discretion of the examiner.
Were you informed by other investigators working on the case that this particular weapon was manufactured in Germany in 1938?
I was not, no.
You did not review a report from an ATF agent who investigated that issue?
No, I don't believe so, no.
In doing your examinations, is it important to know something about the manufacturing process of the weapon?
It is helpful to know how a barrel or any part of the firearm is manufactured, yes.
And why is that?
Certain manufacturing techniques will lend to that individual characteristics. So grinding is a method that is known to leave individual characteristics on a tool. So if an item that I receive, I can tell is finished or manufactured by grinding, it already gives me an indication that individual characteristics would be left from that tool to the tool mark.
Now, once you have your 6 test fires, then you did some comparison between the test fires, right?
That is correct, yes.
And why do you do that?
That establishes whether or not there are individual reproducible marks of value on the test fires. It's important to know that because if there's not reproducibility amongst the test fires, then there's a chance to say, oh, it's not going to reproduce on the evidence and I wouldn't have anything to compare it to.
And have you had cases where you fired the 6 test fires and you don't get reproducible marks?
Not that I can recall.
And when you do your comparisons, just looking at the test fires, do you get situations where there's some dissimilarities between those 2 fired bullets from your test fires?
Yes, there are times there will be disagreement amongst the individual characteristics, even in test fires. You have to think of it as when a bullet travels down a barrel or a cartridge case interacts with a firearm, the marks aren't going to be left onto that item the same way 100% of the time.
It's almost like a stamp. If you know you're using a stamp and you put it in ink and then you put it on two separate areas of an item, it might look a little different just from the way the stamp was placed. It's the same thing with a bullet traveling down a barrel or a cartridge case coming into contact with a firearm.
So even when you know a bullet is fired from the same weapon, you can have 6 bullets fired, and when you start comparing them, you will see differences between each bullet.
There is a possibility to see some areas of disagreement. However, if I'm rendering an identification and saying there is reproducible individual marks of value on these test fires, there will be an overwhelming amount of sufficient agreement of that individual characteristic.
Now, when you're doing these comparisons, you use something called the AFTE theory of identification, don't you?
Yes, the AFTE theory of identification.
All right, and take a look. And that's the standard that you used in this case to draw the conclusions that you made in the report that I showed you earlier, correct?
That is the theory stating how an examiner is able to come to a conclusion when examining 2 or more sets of tool marks. And yes, that is how I go through my examination and how I come up with my conclusion, yes.
Okay. And what is AFTE?
AFTE is the Association of Firearm and Toolmark Examiners. It's the governing body of the firearm and toolmark community, whose primary goal is to further research and continue to show information about manufacturing and the evolution of firearm and toolmark examination. They hold annual seminars, publish a glossary of terminologies used by the firearm community, and they also have a peer-reviewed published journal.
Peer-reviewed published journal. Can I join AFTE?
You can, most of the firearms community, or excuse me, members are firearm and toolmark examiners. There are also technical advisors and associate members. Those members are not usually firearm and toolmark examiners, but they still have a livelihood in firearm and toolmark examination, meaning they conduct research or they are involved in products or manufacturing. And anybody is allowed to come to the annual seminar or get the journal. You just have to pay the fee.
You just have to pay the fee. Okay. Could you display to the witness Exhibit 27, please? Do you recognize what's displayed here?
It appears to be the AFTE theory of identification, yes.
All right, I move that into evidence, Your Honor.
What is it?
This is the standard that she used to make the comparisons in this case, correct?
Would this be Carner 27
This would be Carner 27, Your Honor.
to the state?
Your Honor, if I may voir dire the witness on this exhibit, I've never seen it before, I don't think.
All right.
Sure.
Let's go ahead and do so, Mr. McBride.
When was the last time you reviewed this document?
I'm not sure off the top of my head.
Can you testify as to its accuracy by looking at it now?
Not verbatim, no.
Your Honor, no more questions. My objection is lack of foundation.
Mr. Burt.
Does this document accurately state what the theory is?
May I take a moment to read through it?
Yeah, sure.
I believe something, I think the first statement is different than what I can recall, but overall, it is what the AFTE theory states.
Okay. And your ATF protocol refers specifically to the AFTE theory of identification, does it not?
It does, yes.
Okay. So is there any difference between what's in 27 and what's in your manual?
Again, I don't remember without looking at them side by side.
Okay. Let me get that in front of you. Let's go to Exhibit 12. And go to theory of identification and range of conclusions. Page 1 of 3. I don't have a Bates on it. It's toward the end. It's document FT 10. No, that's not it. Can I quote your witness, Your Honor?
You may.
Page 1 of 3 of your protocol that I think was.
I recognize this as something that comes from our SOPs, yes.
Okay. And it refers to the AFT theory of identification, right?
It does, yes.
Same theory that's displayed in 27?
Yes.
Okay, so I'd renew my offer on 27.
Your Honor, the objection stands. Language matters. Without knowing what, if this language is identical to what she's trained on, that can make a big difference. Whether the word sufficient or adequate is used, these are scientific principles, and we need to be precise in the language that's used. The witness cannot authenticate the exhibit that's been offered, so it should not be received into evidence.
Mr. Burke.
Goes to weight, not admissibility. You'd be free to question her about any differences, but I think she's laid a foundation that the theory's the same, so.
All right. Well, I remind the parties that this is a probable cause finding, and so as it relates to what's been presented, the witness has said that it looks familiar. Again, I don't want to quote you, I don't remember the exact phrase, but she recognized portions of it and then was given the opportunity to compare it to her standard operating procedure. I think she said SOP. For those reasons, Corner 27?
Yes.
Is admitted and may be
Thank you.
published.
Looking at the language of this, the second part of it, according to AFT, says, currently the interpretation of individualization, identification is subjective in nature. Do you agree with that?
Yes.
Why is it subjective in nature?
The conclusions that I author are of my opinion.
Of your opinion?
Correct.
Does your, you can take that down, thank you. And no, wait a minute, go back if you would. But while he's doing that, does your manual state what you're looking for under this theory is correspondence of individual characteristics?
Yes.
That the theory is that if you see a certain level of correspondence, you can make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two tool marks are, quote, in sufficient agreement. And is the subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst two or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
Does your manual state, your ATF manual, section 431, state that correspondence or lack thereof of individual characteristics is not easily communicated? An observation such as significant agreement can mean different things to each examiner. This does not serve as interpretable descriptions of what was observed, because the individual performing the review will likely have his or her own concept of the phrase based upon their training, experience, and knowledge.
Objection, Your Honor. This question goes to weight. Oh, I'm sorry. You don't. May I be heard?
If you're objecting, I will hear the objection.
It's just speaking objection. That's why I stopped myself. This goes to weight. This goes to credibility, and the witness's report has already been admitted as is appropriate under the Utah Constitution, Rule 7B and Rule 1102 of the Rules of Evidence. This is beyond the scope of preliminary hearing for those reasons.
Mr. Burt.
Number one, that's a general objection, which I think has been waived. The state was privy to the interview with this, pre-hearing interview with this witness where these same questions were asked. We had a scheduled hearing where the court was going to rule on objections. The state indicated in advance of that hearing that it had no objections to the testimony, reserving the right to make particular objections. But the objection being made is a global one. And it's relevant because the state offered, the evidence I'm offering here is relevant because the state offered through a hearsay declarant the meaning of this report that this examiner authored. And I'm trying to inform the court on what the limitations are of the opinions expressed in the report that the state offered. And it's certainly relevant to the reliability issue to know that the opinion is based on a subjective standard that the witness herself admits is subjective. So I think it helps the court understand what weight, if any, to give to this report that the state offers.
All right. Mr. McBride, final thought.
That's all fine, but it's inviting the court to weigh the evidence. That's the whole point. And at this point, the inferences are drawn in the state's favor, and the court is not to weigh even contrary evidence.
Okay. Well, in regards to the court as the magistrate bears the ultimate responsibility to ensuring that this hearing is a probable cause standard. And so that's a responsibility that as a magistrate I take seriously. I understand the arguments from the parties. I'm going to overrule the objection, but Mr. Burt, this is, we don't need to go 100 miles down a path where 1 mile is where probable cause may be. And so I invite you to refocus, to bring it to the probable cause. I'm not trying to limit what your theories or such, but I need to hold to probable cause.
Absolutely, and I don't even need a quarter of a mile. This is my last question, and I'm going to move to another topic.
Thank you, Mr. Burt.
Is that what your manual states?
I don't remember it verbatim, but it does sound accurate.
Well, could you pull up Exhibit 12, page... Just to... Can I approach again?
You may.
I'll give you the 2 pages. Bottom of the page, highlighted.
I see where you were reading from, yes.
You see?
Yes.
Did I accurately read it?
I believe so, yes.
Thank you. Can I approach you?
You may.
Okay. Now let's return to the report, the People's or State 32. And if you would go to the second page, please. you concluded here, did you not, that the Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1A based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics? The result of the comparison was inconclusive.
Yes.
That was your ultimate conclusion, right?
Yes.
And on the next page, if you go to 2 pages in, you have an appendix, do you not, where you explain what inconclusive means? Next page, one more. There we go. I want to ask you, because I'm unclear on what inconclusive mean. You say reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification, a lack of any observed microscopic similarity, or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There is a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times that I saw agreement in the striations and the landing group impressions, also seeing disagreement, but there was also a lot of lack of microscopic marks of value to see it all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
Okay, I think you and I have met before today, correct?
Yes.
Where we talked about what that term inconclusive meant, correct?
Yes.
And I think, and correct me if I'm wrong, but did I read to you from a do you recall me asking you whether you agreed with this statement, that an inconclusive conclusion indicates that the microscopic marks in question may or may not have originated from the same or known source?
I do remember you asking, yes.
And you agreed that that was a correct definition of what you concluded in this case, correct?
Correct, yes.
Okay. So I want to, if I could, return to 10, Exhibit 10. And in Exhibit 10, not 10, I'm sorry, your case file again. This is the 47-page document. There we go. What's the tab? 6. Okay. In your case file, you have produced for us some nice comparison photos of your comparisons, correct?
Yes.
Okay. And if you would go to page 37. Is the top photo depicting one test fire on the left and another test fire from the same gun on the right?
Yes, it is.
So do you see areas of agreement and areas of disagreement in these two bullets fired from the same rifle?
I see sufficient agreement amongst the striations that are in this land impression.
Okay, and tell us where they are. When you draw that conclusion, using this subjective theory of identification, show us what you're looking at.
Is it touchscreen?
Probably.
No, it's,
No.
I'm sorry.
but we can, if you direct us, we can get there with a pointer.
Sure. So you can see towards maybe the last third of the bullet or the land impression that, yes, right where your cursor is below there, that's an area of agreement with that striation. It looks like it's going from the left to the right, so that mark is appearing on the test fire on the left and the test fire on the right. Then if you look towards the top of that land impression, there's going to be some more lighter colored striations or lines that are moving from left to right. Those areas are in agreement as well.
Where is that? Not as far up as where he is, correct? It's down?
Yes, and I believe the PowerPoint that I provided does have some areas and circles of some of these marks, if that would help as well. But if you move your cursor up, continually up, keep going. There you go. You have a line that was right there, and you have several others underneath of it that looks like it's going just straight across from left to right, and that shows an observed area of agreement.
So that one he's got circled on the right, I see a line there. Are you saying you see a line on the left that it's identical to the one on the right?
I'm saying I see agreement amongst those striations, yes.
Okay, anything other than those two areas?
You can really go down the entirety almost of that line looking at those striations. So under the top red circle, there's another area there. Yep, if you start right there and you draw your circle over, like I said, at the top of the circle, there's a highlighted line on the left that goes all the way to the right. If you go a little bit farther down, maybe still in the top third of that circle, you can see another line going from one side to the other, another area of agreement as well. And then under the final third circle, in a little darker area down there, there's still some lines, again, in sufficient agreement.
Okay, and again, these are comparisons between test fires. So you know the rifle that you're test firing fired these two bullets, right?
Yes, and the
Okay.
purpose of those test fires is to ensure that though it was fired from the same firearm, you want to make sure that those individual characteristics are reproducing.
All right, so go to the photo on the bottom of that page. This is the first of several comparisons between the test fire on the left and 6A on the right, correct?
Yes.
And what does the writing on the top mean, blue index GIMP?
So that will be, the first number there is the case number, the laboratory case number. Then next 1.11B is going to refer to the specific test fire that's on the picture. And then V versus 6A, so that's the evidence that's also pictured. GIMP stands for groove impression, so I'm looking at a groove impression in this photo. Blue index means that I'm specifically looking at the groove impression that I have put a blue indexing mark on so that I know where I am during the comparison process.
Okay.
30X refers to the magnification that the photo was taken at, and then INC refers to inconclusive, the final conclusion.
So I'm interested in the areas of disagreement. Are there areas of disagreement between the known and the unknown here that you could point us to?
So for this photo, to me, I see areas of agreement in the top. And then on the way down from the 6A, right after you see those two highlighted lines near the top, there's a lot of damage that is observed, and almost no microscopic marks of value can be observed at all. So again, that lends to the lack of quality and quantity of marks even to do a comparison. It's almost like missing data points.
Okay, missing is not the same thing as dissimilar though, right?
It just means there's nothing there to call agreement or disagreement.
So do you see areas of disagreement here or no?
On the striations that are available to me on this groove impression, I see areas of agreement, and specifically talking about those two highlighted lines at the top on the right.
Okay, go to the next page, please. Top photo on the next page. It's B38. Do you see areas of disagreement in this photo?
So this is the same photograph that we looked at before, just at a different magnification. It's zoomed in a little bit more from 30 to 40x. So again, I'm looking at those two highlighted lines near the top, and then if you look down, you can almost see that damage a little bit better, and there's none of those striated lines that you see on the test fire, which you would expect to see in a land or groove impression on the right at all. So again, no microscopic marks of value to compare whatsoever.
All right, how about the bottom photo? And again, the question, areas of disagreement.
The possibility of an area of disagreement may be in the middle. There, on the 6A is a line that does not look like it carries over, but just from this snapshot, I cannot say if I had moved the photo a little bit different or the specimens together, that area would be agreement. In this photo, it does not look like it does, though.
Okay. And could you go to the next photo, please? Same question here, areas of disagreement.
The way this photo was taken is highlighting more of the lack of microscopic marks of value. If I had pulled the specimen that's on the left, the test fire over, there might be some agreement that could be observed, but the way the photograph is now, you don't see the line on the right going all the way over. But again, this is just a snapshot of one particular area.
Doesn't show areas of agreement or disagreement.
There is an area of agreement at the very bottom of the photo.
Okay.
Correct, yes.
Next photo, please. How about this one?
This is another zoomed in of the previous photo, focusing in on that bottom area of agreement. So we went from 30x to 40x and just highlighting one specific area, and this is showing you agreement.
Next photo.
So again, this area that is highlighted, the bottom portion that's in focus, is showing an area of agreement. As you go up, the lines are a little bit blurred on the 6A bullet jacket fragment, so it's hard to say if that area was an agreement or disagreement. That's not what my photo was focusing on.
All right. Next one.
So again, this is going to show you part of the groove impression at the white index. On the top, you can see some striated lines, or excuse me, more of the middle of the photo. The top of the groove impression from the 6A, you see some lines do not appear to be on the right side either, but this photo is also trying to show the lack of microscopic marks at all towards the bottom of that groove impression.
Okay. But there are in these photos areas of disagreement as well as areas of agreement, correct?
In the photo that we just looked at, it could be possible areas of disagreement. Again, it's just one area that I'm looking at. It's hard to tell when you can't look at the entirety of the land in this moment.
Now this, you can take that down, please. Do you keep up with the literature relevant, scientific literature relevant to your field?
I do, yes.
And are you aware of certain criticisms that have been leveled against this AFTE theory of identification?
I have heard, yes, I've heard recommendations on how to improve the AFTE theory of identification, yes.
Well, the criticisms have gone beyond that, right?
Specifically, what are you referring to?
Well, you're aware that the National Resource Council?
The National Academy of Science?
National Academy of Science?
Yes.
Is that a pretty preeminent scientific organization in this country?
Yes.
Did they conclude in 2009 that, quote, a fundamental problem with tool mark and firearm analysis is the lack of a precisely defined process? As noted above, AFTE has adopted a theory of identification, but it does not provide a specific protocol. It says that an examiner may offer an opinion that a specific tool or firearm was the source of a specific set of tool marks or a bullet striation pattern when, quote, sufficient agreement exists in the pattern of two sets of marks. It defines agreement as significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. The meaning of exceeds the best agreement and consistent with are not specified, and the examiner is expected to draw on his or her own experience. This AFTI document, which is the best guidance available for the field of tool mark identification, does not even consider, let alone address, questions regarding variability, reliability, repeatability, or the number of correlations needed to achieve a given degree of confidence.
I do remember
Objection.
there's.
Objection.
We're now firmly into 702 territory. I object on grounds of relevance to the probable cause hearing and beyond the scope of the PC hearing, as I previously objected.
I think it goes directly to reliability. That a group, a scientific group, studied this exact process that she used in this case and reached that conclusion.
If you would, so again, I'm trying to keep us on the probable cause standard. This is going a bit deep in regards to it. This is citing to 2009, and so we're in 2026. And again, I don't want to have to dive deep into areas trying to determine, because I feel that we are exiting the orbit of probable cause. If I'm having to make that analysis and trying to see, like, how is this relevant? How does this apply? How does this go to probable cause? So if you wish to ask this question and then move on, we certainly could do that. But
sure. The only thing I wanted to do was establish that this was the foundation criticism in 2009. And I know when we had raised this issue with respect to one of the other experts, the comeback was, oh, well, this was in 2009 and the PCAST report was in 2016. In this particular field, these criticisms have started in 2009, but they have continued up to the present day and have gotten more strident. So I think that's the take home here, is that this is not some past criticism that has been set aside. This is a criticism that this expert is aware of and that has continued in the literature up to the present time.
But I don't have that second portion of what you just said in front of me. So I can't agree with you, because what I have is what's before me. I can't go searching myself as a magistrate for probable cause. I have to take what you say as it is. And if I have to start searching, I've left the universe of probable cause.
I agree, and I was offering that to the court as a proffer in terms of where this line of questioning is going, so the court can understand the context. It isn't just an isolated criticism, and I'll establish with a couple of questions that it's continued up to the present time.
So I will overrule the objection, but I will limit you to this question. We're going to more and more and more. I see your point. You're looking at whether this science is challenged or not. The point's been received, but anything further goes outside of probable cause. So we have to get back on the path.
Got it.
Thank you, Mr. Burt.
You're aware of that criticism, right?
Yes, I am.
And you're also aware of the criticism leveled in 2016?
Counsel, I just said that we're focused solely on, I've accepted what you've said, but I said that it's limited to this question, and then we're moving on, because anything further is going outside of probable cause.
I misunderstood. I apologize to the court.
I apologize if I wasn't clear on that, so maybe it was my error not communicating. I've accepted that coming in. I've overruled the objection, but I said we're gonna leave that where it is and then move forward.
And that's where I'm unclear. When the court says move forward, no more questions about any further criticisms beyond that one?
On this line of question, that's correct.
Okay.
Thank you, Mr. Burt.
And I think I've made the proffer in terms of the relevancy of it.
And I accept that, so thank you, Mr. Burt.
All right, then the last area is In the years that you've been doing this testing, is it true that you've only taken one proficiency test that involves bullet comparisons?
Yes, I've only had the opportunity to take one bullet proficiency test so far.
And is it true that that was in 2023?
I don't remember the exact year, but that sounds correct, yes.
Right. And is it true that that proficiency test involved a test where you had question bullets, and then you had two sets of bullets, one that was fired from one gun, not the suspect gun, and then a second gun that was fired from another gun?
I don't remember the exact final ground truth answers that were there. No, I'm sorry, I don't remember.
I think when you and I talked about this, you said you were aware of a controversy about that particular test, correct?
I was aware, yes, of the results of the proficiency test, yes.
That there was a very high error rate in that particular proficiency test, right?
There was a higher error rate, yes. However, my answers were satisfactory, along with the 5 other examiners at my specific laboratory that took it as well.
Your conclusion in that case was, as in this case, that it was inconclusive, correct?
Correct.
Even though the correct answer was that the bullets did not come from the question, the two did not match, the known in the question should have been an elimination.
The ground truth answer was yes, they were excluded. However, an inconclusive result in this comparison was extremely appropriate. The lack of quality and quantity of those individual characteristics never reached sufficient agreement, nor did it ever reach sufficient disagreement. So saying anything but inconclusive was not appropriate.
I see. And can you have bullets fired from different weapons that can have individual characteristics that look pretty similar?
There is occasions, yes, that tool marks that are made by 2 separate tools are similar, yes.
Could you go, and this is my last area question, Exhibit 19, page 26.
Your Honor, I'm requesting
Page
20 minutes
26.
for cross-examination. We're coming up on 4:37. That would be my request, Your Honor.
This is my last question. So.
All right, Mr. Burt. Thank you, Mr. McBride. I appreciate the heads up.
In your opinion, does this, the one on the left and the right, show matching individual characteristics?
Counsel, has this been admitted? Because I see it displayed. I just want to make sure. Is this also?
It has not been admitted, and
Okay.
I'm asking this question and as a foundation for admitting it.
Okay, that's fine. So I just
Yeah.
want, it was on another screen. I wanted clarification, so it's not on any screens because it hasn't been admitted, but clearly it can be on her screen.
Thank you.
So only to the witness and counsel table screens.
Page, Exhibit 19, page 26. Does this comparison show individual characteristics indicating that it was fired from the same weapon?
There are individual characteristics present, but without examining it in person, I don't feel comfortable making a conclusion.
Okay, how about the next page? Watch, 27. How about that one?
Again, I see individual characteristics. On a very first glance, I can see maybe one striation that is an agreement, but without seeing it physically in person and having an accurate representation of the entirety, I can't conclude in any answer.
And the last one, the third photo, page 28. Page 28. Exhibit 19, page 28. Same question.
I do see individual characteristics. I do see some areas of agreement without looking at it further. I wouldn't make a conclusion. It's a holistic approach when you're examining items.
Would it surprise you if I told you that all three of those were fired from different weapons?
Again, I don't know any context to these photos other than what you showed, so I don't feel comfortable saying one way or another.
Thank you.
All right. Mr. McBride.
Good afternoon.
Good afternoon.
Those last three photos that you were shown, had you seen those before?
I have looked at them probably back in 2024 when it was published.
Okay, that's a study. Is that what that is? Of some
Yes.
sort?
It was a look from the Association of Firearm and Toolmark Examiners. It was a volunteer of photographs of people that did have an incorrect answer in that proficiency test.
Okay. And when you do an examination or a comparison, are you limited to one photograph?
No.
You actually have the item in front of you, correct?
That is correct, yes.
And you can manipulate it, you can turn it, you can look at every angle and every side of that item as you do the comparison. Is that correct?
Yes, that's correct.
And as you're doing that process, you're looking for as many characteristics that match or agree or disagree as you can possibly find, correct?
Yes, it's a holistic approach. If I have a bullet like this case, I'm looking at every single land, every single groove impression, and doing an evaluation of each one of those, looking for areas of agreement and disagreement before rendering a conclusion.
Would it be responsible for you to reach a conclusion based on a single photograph of a very limited area of two bullets?
I would not feel comfortable doing that now.
Okay, I want to back up. How long have you, first of all, where do you work?
I work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you been there?
A little over 6.5 years.
Where did you come from? Where did you work before that?
Prior to working for ATF, I was a latent fingerprint technician, recovering latent fingerprints from improvised explosive devices, and I also worked as a crime scene investigator in Winston-Salem, North Carolina, and Anne Arundel County, Maryland.
How long did you have that position?
I think cumulatively it was about 5 to 6 years.
And before that?
Those are the only ones. I think it was about 6 months as a latent fingerprint technician, 2 years as a crime scene in Winston-Salem, and 3 in Anne Arundel County.
Do you have education and training before that position?
Yes, I have a Bachelor of Science in Forensic and Investigative Science from West Virginia University and have attended and graduated the National Firearms Examiner Academy, as well as done specific training at my laboratory.
At each of the positions you've held, have you had on-the-job training at the laboratories where you've worked?
I have, yes.
And will you describe what that training is like at the ATF where you are now?
Yes, so part of becoming a firearm and toolmark examiner for ATF was attending the NFEA, the National Firearms Examiner Academy, which is a year-long intensive comprehensive training program. I learned about historical cases, figures, and the evolution of firearms, fired ammunition components, and manufacturing. In phase 2, I worked 16 weeks of hands-on experience assembling and disassembling firearms using a comparison microscope comparing fired ammunition components and tool marks, going on manufacturing tours, and participating in moot court. I worked on an independent research project and 4 practical exercises, and then presented that independent research project to a panel of experts and participated in 2 moot court sessions on 2 of those 4 practical exercises. Then specifically for ATF, I still work on my training, going through practical exercises and competency tests, working under trained firearms examiners at my laboratory, and also continue learning about any manufacturing evolutions or going on manufacturing tours. And I also participate in moot court for every single competency test that I work. Once all of that is complete, then I work on supervised case before moving on to unsupervised casework.
And supervised casework means what?
It means that the author of the final report will be a different examiner, but I am working on all of the work side by side and going through all the steps that are needed for that examination.
And in that process, you're having discussions and discussions about your work with a more experienced examiner.
Yes, it's an opportunity to work a case that has come into the laboratory, but still have someone there making sure I feel comfortable with everything and following every step necessary.
How long ago was that you had that, that you graduated from that supervised work?
I believe that was in 2022 or 2023. I'm not sure.
Do you supervise now others?
I do not have a supervisor capacity, but I have had the opportunity to now teach at the NFEA. I've been fortunate enough to participate as an instructor in the test firing module, the mini moot court module, and the comparison of bullets and cartridge cases.
Are you required to undergo continuing education in your position?
There is not a specific continuing education program. However, when the opportunity to go on AFTI's annual conferences and it allows it, I will go to those, as well as continually go to manufacturing tours.
Is this an area of science and forensics that is continuing to develop new techniques and advance in research?
Yes, it is.
And how do you stay up on those advances?
Part of the way to do that is to continue my membership with AFTI. Again, they do an annual training seminar recently, just in May of 2026 here in Baltimore, where there's case searches and studies that are presented, different manufacturing techniques, just new and upcoming research that is throughout the community, not just firearms practitioners, but also standard and technology researchers like those from the National Institute of Standards and Technology, or NIST.
And I think Defense Counsel has asked you a little bit about some of the publications that have given criticism is how he's phrased it, but given recommendations on how to improve the science in your field. Are you aware of that?
I am, yes.
And is there an effort to adopt those suggested improvements where they have merit?
Yes, AFTI especially takes those recommendations very seriously. If the PCAST asked for more specific design test studies, they said, yes, we will do that. I can think of just a few right off the top of my head that has satisfied those asks that they wanted.
Is your laboratory accredited?
It is, yes.
What does that mean to be accredited as a laboratory?
An accreditation means that my laboratory is held to an international standard of reporting, testimony, training, and proficiency tested. We have a large audit every 4 years through ANAB, or the American National Standard Institute, National Accreditation Board, but we also do internal audits, and we make sure there is some type of audit that we are staying in within those accreditation limits every single year.
There is a mention of proficiency testing. Are you required to do proficiency testing?
Yes, I am.
And are those specific as to what type of proficiency testing that you do?
Yes.
What are some examples?
We are required to take proficiency tests in all discipline that our scope enables, so serial number restoration and the comparison of tool marks, bullets, and cartridge cases.
Are there similarities and principles that apply to all aspects of tool mark analysis and comparison?
Can you elaborate on the question, please?
Well, let's say you're comparing what we've been talking about here, rifling on a bullet. Are there principles that apply to that area versus that also apply in tool marks analysis, say of impressions of a handheld tool?
Yes, all of those comparisons are a product of a tool mark comparison. A firearm is nothing but a tool. So when you are talking about a cartridge case comparison, it's still looking at a tool and a tool mark. The tool in this case is the firearm. The tool mark is being left on a cartridge case or a bullet.
I want to draw your attention to Plaintiff's Exhibit 32. Thank you. Well, that's pulling up. And this has been published, this has been approved for publication at all 3 levels already, so we can put that on the screens. Well, that's pulling up. Thank you. I want to ask you first about an entry here. The second sentence under results of examination. Exhibit 1 rifle was test fired and found to be in operable condition. Did you perform that test fire?
I did, yes.
How did you receive this firearm?
I received it from another physical scientist in our laboratory.
Okay. And did it have a scope on it?
Yes, it did.
What did you do to determine if it was in operable condition?
In order to determine if the firearm is in operable condition, I will find ammunition that it is calibered for. In this place, it was 30-06 Springfield. Load that into the firearm, and then I fired any test fires into our water recovery tank.
Okay. And why do you choose a water recovery tank?
The water recovery tank is what is used to obtain bullet specimens. The water is going to slow down the bullet from its movement so that we can actually obtain the bullet, and it is supposed to cause minimal damage.
Why does it matter if there's minimal damage or more damage?
You would like minimal damage because that means that there's going to be less damage on the areas that you need to compare.
And the evidence rounds that you, or in the bullets that you often receive in your cases, are there cases where there's a lot of damage to those bullets?
I have received cases with lots of damaged bullets, yes.
In this circumstance, Exhibit 1 rifle, this Mauser 98 30-06, was it an auto-loading rifle or a bolt action?
This was a bolt action rifle.
Exhibit 2 cartridge case, let's see here. If you'll turn to page 2, and we've already read this line. I think defense counsel read this line to you, the Exhibit 6A paragraph there. The result of the comparison was inconclusive. Could further testing be done to try and see if there is any, if you come to a conclusion on this round?
There was no further testing that I could do, no.
Is there further testing that could be done in the field?
There is the possibility of using a 3D system to visualize the individual characteristics on the bullet.
Do you have the capability of doing that at your lab?
My laboratory currently does not have that capability.
Do you know if the FBI lab does have that capability?
I believe they do.
Defense counsel put up a list of potential firearms that could have fired this round, or this bullet. Is that list comprehensive?
It's not an all-inclusive list.
And does it mean that this round, I'll leave it at that actually. There's been some discussion about the 6A bullet jacket fragment. Will you describe what a bullet jacket is?
Yes, I do have a demonstrative. May I use that?
Do you have that with you? Yes. Yes, please, go ahead.
So this is a demonstrative of a bullet. So a bullet jacket, it would refer to the outside of the bullet. Inside the bullet would be the lead core. So when I'm referring to the jacket, it means that I've only received that outer portion. I did not receive any of the lead core intact with it.
In this circumstance, you received a bullet jacket fragment. What does that mean that it's a fragment?
Fragment means I don't have the entirety of that jacket.
And can you testify as to why you don't have that entirety?
No, I cannot.
And it also, your report also says that there are 4 lead fragments. What is this? Why would you have lead fragments?
So the lead fragments, the lead would be from the inside of the bullet, that core. Occasionally when the bullet reaches its final destination, it can split, and some of that core might be pulled off of the jacket and be found where it landed.
And would you be able to gather information from those lead fragments that could identify them as coming from this particular firearm? Would you expect to be able to make that comparison?
I would not expect to see any characteristics that would help me reach a conclusion, no.
Why not?
Because the lead core is on the inside of the bullet, the landing grooves are going to be imparted onto the jacket or the exterior. So when it's moving down the barrel, the inside is not coming into contact with rifling whatsoever.
In this case, do you have a verification step where your work is reviewed by another analyst?
We do, yes.
And were your conclusions in this case verified by another analyst?
Yes, they were.
Is there a potential that the testing you do can destroy the evidence that you're reviewing?
What do you mean?
Well, prevent it from being tested in the future.
No, I would not expect anything that I've done to prohibit more examination in the future, no.
But in general, you say you peeled back the petals, I think you said, of the bullet jacket because it was so crumpled.
Yes. I think, if anything, that lends to a better comparison process. It is a very well-known practice amongst firearm and toolmark examiners. Without doing a examination like that in preparation, no one's able to see the marks that are needed for the comparison process.
Okay. In reaching the conclusions that you did in this case, did you follow the protocols and practices that are required by your position?
I did, yes.
Nothing else?
Mr. Bird.
You said a couple of things of interest to me. One was that your work is peer-reviewed, right? There's a peer reviewer, a second reviewer?
It is a verification process.
Verification process. And you know, in this case, we requested to produce the case file from your reviewer so we could see whether it was accurate or not. You're aware of that, right?
I am not, and the verification process does not require that the verifier has case notes. Their case notes would be within mine, and it's just an authored verification chart.
Well, you wrote a memo to Mr. McBride dated May 19th, did you not, in which you said in answer to our request for the reviewer's work product that ATF laboratories do not release materials concerning technical reviewers or verifiers. And you went on to state, did you not, that we don't even release the CVs of who the reviewers are.
So that is not authored by me. That is our ATF procedures and protocols. If that was an email that came from me, I am just verbatim what our quality assurance manager has said.
Do you think science works best when it works in secret?
Objection. Objection, argumentative.
Counsel?
It goes to the issue that was raised on cross-examination, which is my work was peer-reviewed. So how do we evaluate the strength of that assertion when they refuse to hand over to us the work product of the reviewers, or even identify what their credentials are? That's relevant.
Well, I'm not agreeing or disagreeing with that, but the question itself was argumentative. Because we can look at the question, working in secret
Let me rephrase.
Okay, so I am going to sustain the objection. Because of the phrasing, it is inherently argumentative, and it wouldn't be a question that would be able to proceed into prelim.
Do you have an opinion on whether it is scientifically defensible to rely on a peer reviewer and not reveal that peer reviewer's work product?
I believe I understand what you're asking. However, in this case, the verifier does not have any work product to show. If you'd like to see their CV, I cannot testify to anything about the procedures of giving their information out. All I can say is that they are employed at my laboratory, are under the same scrutiny of proficiency testing, went through the same training with competency and practical exercises, so they are a trained and competent examiner.
They don't have any work product to show, but your protocol calls for, does it not, documentation of whatever it is they did.
And that is included in my case file.
Right, but not the reviewer's work product.
The reviewer's work product is a verification sheet. If you'd like, I can refer to my case notes and find that specific page number, but that would be the only work product that they would have in this case.
I see. Now, you said two things about the PCAS report on cross-examination. One was that, if I understood it, that the PCAS findings have been addressed in subsequent studies. Did I hear that correctly?
Because one of the recommendations was to further, actually I think the recommendation was one more black box study to show the foundational validity of firearm tool mark examination, and since 2016 several have been published.
All right, let's look at that for a second. First of all, they didn't recommend, they found, did they not? Quote, PCAS finds that firearms analysis currently falls short of the criteria for foundational validity because there is only a single appropriately designed study to measure validity and estimate reliability. The scientific criteria for foundational validity requires more than one such study to demonstrate reproducibility. Isn't that what they found?
That is what their finding was, correct.
Okay. And then after that report was published, in 2017, they came out with a second report because people said, oh, the literature already exists, you missed it. And they said, no, that's not true. Isn't that right?
They concluded.
Relevance to preliminary hearing, we're now well into 702 argument.
He raised this issue on cross, Your Honor. He clearly went beyond the 2009 reference that the court allowed and opened this area up. And I don't think it's fair for him to be allowed to do that without me being able to respond to it.
Thank you. On cross-examination, that door was opened by the state, and so I will allow limited questioning on recross or redirect, however we want to label this. So you may proceed. The objection is overruled.
In 2017, they filed a second report responding to assertions by people in your profession and others that they had missed or the studies had already been done. Isn't that true?
Yes, PCAS did a 2017 addendum to their 2016 report, reiterating that they believe that the only way to properly empirically test a science is through these black box studies, and that they would not take into consideration the numerous amount of work and validation studies done over decades that the firearms community has published.
And a bunch of other studies were done, right?
Correct.
And in response to those additional studies, there have been continual criticisms of the methodologies of those studies. Isn't that fair?
Yes.
And you've read, for instance, well, first of all, you attended, I see, a webinar by the group that did some of the critiques. Remember that?
Which webinar are you referring to?
You attended a webinar, I believe, in 2023, Treatment of Inconclusive Results and Error Rates of Firearm Studies. Webinar hosted by the Center for Statistics and Applications in Forensic Evidence, 2021.
Correct, I did.
According to, and that group has published a number of studies right up to 2026. For instance, their study in 2024 called Methodological Problems in Every Black Box Study of Forensic Firearm Comparisons, in which they concluded that the field still was not reliable despite the studies that you reference. Isn't that true?
That is the author's opinion, correct.
Right. And they're not the only ones. There have been other groups of statisticians who have published articles right up to 2026 saying that the studies that you referenced are unreliable.
Yes.
That their methodology of those studies is flawed and cannot be relied upon to support the science of toolmark comparison, correct?
Yes, there has been studies to say that they believe there is flaws in the black box studies and stuff, but there has also been plenty of research done to say the opposite.
And lastly, you mentioned that, or it was brought out that you have training and experience, right?
Correct, yes.
Do you agree with the conclusion stated in the section of the report, the PCAP report, that neither experience nor professional practices can substitute for foundational validity? Do you agree with that?
I do, yes.
You agree with the conclusion reached in the PCAP report that a forensic science discipline that has an error rate higher than 5% is not reliable?
I don't know that I have opinion to that because I think it's a little on the broad side. I don't know what you would consider high as far as the percentage.
Well, I'm referring to the statement at page 151 where they say methods with a high false positive rate are scientifically unreliable for making important judgments in court about the source of a sample. To be considered reliable, the false positive rate should certainly be less than 5%, and it may be appropriate that it be considerably lower depending on the intended application.
I would agree with that statement.
You would agree with that. And you also lastly reference your knowledge of the study by the AFTE of that proficiency, the one proficiency test which you have taken on bullet comparisons, correct?
Correct.
And the error rate in that particular study, proficiency test, was 20.4%, correct?
Correct.
For item 2, 18.2% for item 3, and 18.9% for item 5.
I believe those were the results. However, I don't agree that proficiency tests are what are used for validation studies to show foundational validity.
So if the error rates are high, then they shouldn't be relied upon to show invalidity, but they should be relied upon to establish that your experience means that your science is valid? Is that what you're saying?
Foundational studies are looking at, just as PCAS said, those black box studies, different test design, all of which firearm and toolmark community has conducted. We've looked at cartridge cases, bullet, pristine samples, damaged samples, and different firearms. Proficiency test is looking at the accuracy of an examiner's results, not foundational validity.
You would agree that an error rate of 20% is unacceptable, would establish unreliability, correct?
I would agree that those results need to be looked at to see where that error was coming from.
Right. Okay, thank you.
Thank you. Anything further for this witness? And Mr. McBride, I'm going to limit you because your objection to going outside and going to 702, you open the door, but I've got to close that door to some point. So I will give you a limited number of questions. We need to come to a close.
I understand that. Your science has been accepted by courts across the country, correct?
Correct, yes.
It's routinely admitted in courts across the country, correct?
That is correct, yes.
Your science has been peer-reviewed and viewed favorably by numerous publications and studies across the country and across the world, correct?
Correct, yes.
No more questions.
May this witness be excused. Thank you, Mr. Burt. Thank you, Mr. McBride. Ma'am, thank you for being here. You are excused. All right, that brings us to a close. Do either party wish the benefit of the record before we adjourn for the night?
Your Honor, can you just give us about 5 minutes, and then I think we can make an announcement. Can you just give us a minute to chat?
Yes, you may have that, and we'll stay in court for these 5 minutes, just because it would take longer to let everyone go and then come back in. 5. So court is back in session. All the parties are present, except for maybe one attorney. Mr. Grunender, should we wait for counsel?
Take maybe 30 seconds to wait for Mr. McBride.
All right, we'll wait for Mr. McBride. I just want to ensure all the attorneys are present. All right, I note the presence of all attorneys. Turning to Ms. Nestor.
Thank you, Your Honor. Your Honor, we have just one more witness who would be a fairly short witness, not super long. So I anticipate we will be done tomorrow, probably by lunch, I would think. So maybe if we could plan that we'll be finished. We probably will not need the entire day tomorrow, is my suggestion. Yes.
All right. Turning to the state, obviously I'm not holding you to your answer today, but just for guidance, does the state anticipate and rebuttal witnesses?
Judge, we don't anticipate any rebuttal evidence that needs to be presented to this hearing. So I think the question would be is, are we going to argue the bind over tomorrow? And the state would be prepared to argue bind over tomorrow.
All right, well, I appreciate that. In regards to trying to budget time here, how much time does the state anticipate? Obviously, there's one more witness, so I'm not going to.
If it's a short witness, Judge, I don't think it should take us the entire morning. But we would be prepared to argue tomorrow morning at the close of evidence or first thing in the afternoon.
And how much time do you anticipate that argument being? Again, a rough estimate. I'm not holding you to the exact number. I'm just trying to see how close are we to the 5 o'clock, because I'm going to ask the defense the same question as well.
It wouldn't come close to the 5 o'clock hour, Judge.
For just you or for both?
For argument?
Yes.
Both of us.
Okay. All right. Well, I'll turn it. Thank you, Mr.
If we have to argue 2 hours apiece for bind over, there's a problem.
All right. Thank you, Mr. Grunender.
Thank you.
To the defense, I'm just getting an estimate. I'm not holding you. I'm not going to time you to this, but I'm just trying to see as it relates to 5 o'clock and for argument for bind over tomorrow afternoon.
Understood, Your Honor. Our request, the defense request, is that we be allowed to submit briefing. There are some legal issues that we would like to brief for the court prior to the decision on the bind over. We're open to briefing, page limits, time limits, all of that, but we would like that opportunity because there are some legal complexities involved here.
All right, and if, and I'm going to ask the state, but if the state, well, I'm not going to assume anything. Thank you.
I believe the state is going to object to that, Your Honor.
So what I hear you saying is you wish to, well, I don't want to assume, what it seems like you're saying, and I want to be clear, is you're waiving oral argument and just doing briefing.
So generally, Your Honor, in cases with multiple counts that are pretty complex issues of law, I have asked for briefing and the opportunity for an argument. We can set time limits on that as well prior to bind over. I've done this in multiple other cases before courts in Utah, and that is my preference, to make sure we get the law right.
And so how much time, if you're asking for argument, that in addition to briefing, I'm trying to get the total universe of what's in front of me.
So I anticipate that, I agree with Mr. Grunender that I don't think an argument would take more than a half day. Should take less than that, particularly if we're briefing issues beforehand. So, I don't know, 2 hours for argument total.
All right. Thank you, Ms. Visser. Turning back to the states, you've heard from the defense.
Again, Judge, the state would prefer to argue tomorrow. We think the court has all the evidence before it and could make a bind over decision. after oral argument tomorrow. If the court decides that briefing is necessary, I believe the court reporter could have a transcript available as early as Monday of next week at an expedited, on an expedited request. With that said, each side would need, 2 weeks to, we're the moving party. We would prepare a motion in support of bind over. There would be a response and then a reply. So we're probably 6 weeks out before we can actually argue before bind over. We would rather not wait 6 weeks to argue bind over. That's why we would like to do it tomorrow. But that's the timeline we're probably looking at, is about 6 weeks and then 2 to 3 hours of argument.
So are you requesting to move forward with oral argument tomorrow and in addition to briefing? Or again,
No.
I'm just trying to see the whole universe that's before me.
Good question, Judge. If the court wants briefing, I don't believe we would argue tomorrow. We would save that argument until the briefing is finished.
All right. Thank you. And to defense, would you agree on the time frame for briefing as been proposed by Mr. Grunander to allow each side the appropriate time, taking into consideration a transcript which may or may not be needed by the parties?
We are also okay with simultaneous briefing on this if the state prefers that. That wouldn't take 6 weeks if that's the concern, but we have no objection to the 6 weeks.
All right. And does your client waive any speedy trial rights that may result as this request? I just want to make sure I'm addressing constitutional rights. Also going to be addressing from the victim representative. This goes squarely into the victim's rights to speedy disposition. So again, I'm just trying to take it, and I know we're late. I just want to cover all these bases.
Yes, our client will waive his right, his speedy trial rights, so issues.
All right. To the state.
If the court wants briefing, we would not like to do simultaneous briefing. We would like to start it out as the moving party. The defense would then respond. We would then have the opportunity to reply before oral argument.
All right, and I'll invite Ms. Kirk's attorney if you wish to be heard. This goes squarely into the victim's rights as recognized in the Utah Constitution as well as the Utah statute as it's what's before us.
Your Honor, obviously we want swift justice for Charlie here. I think we obviously know the court needs to make sure they're balancing all interests here, but I think as soon as the matter could be bound over and this matter could be set for trial, that's what the Kirk family would like.
But do you want to weigh in regards to briefing? Because it sounds like it's...
Your Honor, I'm hesitant to weigh in on briefing. I feel as if that is a decision which the court should decide whether or not it's necessary, and we're going to take no position on briefing. We asked for speed. This has been 10 months coming. We've heard a lot of evidence. To me, it seems rather overwhelming, but that's my opinion. Obviously, it doesn't matter. So we just asked for it to move quickly.
Thank you. All right. All right, having heard from the parties, I will go ahead and allow, I'm granting the request for briefing as it relates to probable cause to allow both parties to file their briefs. With defense, as you are the moving party requesting briefing, when would you like to submit your brief? Or to the state?
Judge, because we have the burden, I believe it's appropriate for us to initiate the briefing.
Okay.
Because we're moving for the bind over, and then we would have an opportunity to reply.
And that's okay. So let's start. Mr. Grunander, when can you have your brief filed?
Just a moment, Judge.
Thank you. And in going to defense, well, I'll follow up with you as well.
Thank you.
One moment, Mr. Grenander. I'm trying to get logistics so we can move this along. Mr. Grenander, turning to you.
Judge, if we were able to collect the transcript Monday, if we had 2 weeks from Tuesday, we could have our motion in. I believe that's the 28th of July.
All right. So state's briefed by the 28th of July, assuming that they can get the transcript by Monday. All right, state's brief. Okay? Ms. Visser.
We need 2 weeks after that, so August 11th, I believe, is 2 weeks.
All right. And to the state, if you wish to file a reply, when?
It would be 7 days after that, Judge. So the 18th?
August 18th. All right. And for oral argument, what I can set is September 1st in the morning. Let me take a quick glance here at the calendar. I'm trying to keep that close in time so we can move this along for all reasons previously stated. And we can start at 10 a.m. 10 a.m. on September 1st. How does that look for the parties?
That works for the state.
Your Honor, I'm going to be in trial that week, and I'd really like to be here for this argument. Is there any way we could just do it the next week?
Well, the problem is, I'm happy to look, but it is getting it would be very tricky. This is a fortunate opening.
Got it. All right.
Otherwise,
we'll take it then.
Okay. I appreciate you accommodating the court schedule. September 1st, in person? I see the defense nodding yes.
Yes.
Yes, please.
All right. September 1st at 10 a.m. And it sounds like up to 2 hours per side, and we can take it from there. Mr. Grenander.
Judge, page limits. We spoke as a team, and our preference would be to limit at least the initial briefs on both sides to 30 pages, no longer than 30.
Defense stipulates to that?
I'd like to counter with 40.
Okay. Well, this is not an auction, but any final thoughts?
We'll submit it, Judge. And then we would ask for half of whatever Your Honor grants for the final reply.
All right. We will set it at 35 pages, and then we will go half of that, which is an odd number, 17. We'll go 17 pages for the reply. Parties agree?
I was going to offer to round up to 18, but
I
that's
know.
fine.
We'll take the 18, Judge.
All right, we will go with 18. So 35 pages for the initial filings, 18 response, and September 1st at 10 a.m. Anything further for this evening?
Yes, Judge. I believe the Kirk family, there was a ruling that was reserved by the court with respect to publication of an exhibit that probably needs to be addressed.
Yes, and now my understanding is what's being requested is the portion that had been altered, which I believe is about 1 minute.
Your Honor, I believe it was enhanced in that it was like zooming in and circles that were put on it. We would ask for the entirety of that exhibit to be displayed in court. So I believe it was about 8 minutes, if I'm not mistaken. Don't hold me on the time.
All right. Any final input on that? Thank you for reminding me from defense. Any final inputs? All right. What we can do is at the conclusion of defense's presentation of whatever witnesses they're going to do, we can address that. So the concern I heard was that the victim representative wanted to see what the court would consider before bind-over decision is made, and that allots for that. So whether it happens right now, which the hour is late, or by right after the conclusion of evidence, that's going to help well before I consider bind-over. So in the interest of justice and balancing that, I don't want to take away time. It sounds like we're going to be okay, but I always want to be cautious. but I will grant that request, and that will be played in open court, and we will watch the totality of, I believe it is State's Exhibit 12.1, which is 8, give or take, 2 minutes.
Your Honor, and just to clarify, it will not be televised, correct? It's only for people in the courtroom.
That is correct. Because the request was made by the victim representative who is present in court,
Right.
I will grant that request, and it will be played in the courtroom for all present to see, but not to be broadcast on TV.
And we just would like a continuing objection for all the reasons we raised before, Your Honor.
Thank you. I appreciate you making that record. I note the standing objection. That objection as it relates to this request is overruled, and that will be played at the conclusion of defense's presentation of evidence and before the state, if they do have a rebuttal witness. Please remind me so that I can address it, and that is taken care of. Thank you to the parties. I'm hesitant to ask this. Anything further? All right.
Nothing
See
further
now.
from the state.
All right. Thank you all. I appreciate your hard work today, and that concludes court. We are in recess till 9 o'clock tomorrow morning.
All right.